Good morning. The time is now 9:30 and I shall resume this inquiry into the appeal made by Rainier Developments Limited, Samuel Gray and Robert Clark under Section 78 of the Town and Country Planning Act 1990 against the decision of Braintree District Council to refuse planning permission for an outline planning application, some matches reserved, for the residential development of 37 dwellings, including 40% affordable housing, with vehicular access, areas of landscaping and public open space at land to the west of the A131 High Garrett. This is the third day of the inquiry. Again, please, can mobiles and desk phones be turned off or on silent? On the second day, I carried out the Housing Land Supply roundtable session, and I started also to hear from the council's planning witness. Today, I will continue to hear from the council's planning witness and then the appellant's transport and accessibility services witness. Again, as per yesterday, there should be an attendance list in circulation. Please add your details, even if you had not been present previously. In relation to outstanding matters from yesterday, I have received from the council an affordable housing note, current supply projections. Mr. Easton, have you received that document?
Yeah, sorry, so I was going to take my earphones out because I'm getting a bit of. Give me. So yes, that came through only a few minutes ago.
Okay.
I have a couple of points to make about it. If I can do that now, if that's convenient, sir.
Yeah, absolutely. Yes. Yeah.
So you recall that the reason we asked for justification was because in oral evidence yesterday, Ms. Banks referred to a projected delivery of 408 affordable dwellings over the current financial year 21 to 22. That hadn't been in evidence before, so we queried where that came from. So we were only expecting an explanation as to where that figure came from. We've got that. It actually isn't 408, it's 424 according to the note. But what then follows in the rest of the note is a series of detailed tables in which the council identifies what it claims will be the deliverable affordable housing supply over the relevant 5-year period that we're concerned with. That was not what we asked for. That is new evidence, and it would require some time to respond to. What I don't have a problem with, sir, is a short note explaining where that 408/424 came from. What I do have a concern about and do object to is a detailed table, which what the council appears to be trying to do is show that things are rosy in the affordable housing garden and demonstrate that they will be doing extremely well over the next 5 years in terms of their affordable housing delivery. That's what I object to, because we haven't had an opportunity to look at that, to interrogate the sites, the likelihood that they will be delivered. That's my concern, sir. Okay.
So, Mr. Easton, so essentially the first page you don't have a concern with, but it's just the tables after which follow. Is that essentially your position?
Partly, sir.
Yeah.
The first page, though, does include a reference to anticipated completions over the next 5 years, and a figure is attached to the council's anticipated completion of affordable dwellings over the next 5 years. So it's a partial yes to your answer, sir.
Mr. Williams, it does appear from my viewpoint as well as go quite a way beyond what was raised yesterday in evidence in terms of detail in this note. So why is it coming in this sort of detailed format?
Thanks, sir. First of all, can I apologise if you can hear a leaf blower outside? It's causing me distraction. I hope it doesn't cause you. The reason it has come forward in this format is that the information derived about the projected supply of affordable housing for the current monitoring year, 2021-22, was taken from the broader spreadsheet which the council keeps updated from time to time. So it was thought that it was best to provide that and an explanation of that. I can understand and I appreciate my learned friend's concerns, and can I try and assuage them by this? For the purposes of my closing, I can make it clear, and I can reissue that if you want, that I will not be seeking to rely on the proposition that the council, for the purposes of this inquiry at least, can deliver or is anticipating to deliver 1,771 affordable completions over the 5-year period. What I will be seeking to rely on is only the anticipated deliveries within the 2021-22 monitoring year, which is the evidence to which Ms Banks spoke. Yesterday. So if that, I hope that assuages my learned friend's concerns in that regard.
And within that note, Mr. Williams, where is that precise information?
Well, sir, then if you look on the first page, the first 2 paragraphs explain the context, and the third paragraph, it's actually the first 2 sentences of the third paragraph. One can ignore for the purposes of my closing. I won't seek to rely on it. Because it does introduce new evidence. I appreciate that. The last sentence of the third paragraph, and on the tables, one only needs to have regard to the 2021 year, and one can disregard, for the purposes of this inquiry, make it clear, and for my closings, the information contained for the 22-23 years and beyond. Because I can understand very fairly, Mr. Easton says, well, look, that is a new point that's being raised over and above that which was advanced orally.
Okay.
It wasn't intended in that way, so I'm sorry that I didn't make it clear that we weren't seeking to rely on it because it hasn't been advanced that way. It was just to show how the number that Ms Banks gave in oral evidence was derived and where it was derived from.
Okay. Mr. Easton, if we proceed on that basis and the remainder of the document is effectively struck out, would that alleviate your concerns?
So to an extent, I'm grateful for my learned friend's indication that you're not going to try to rely upon the claimed supply of the next 5 years. It seems to, the difficulty I have now, so you've got the note. You've got the note with that information in and the council's claim in relation to the 5-year supply of affordable housing. I think there is a better way forward here. I don't think it would take too much time for the local authority to excise from the note and the attached tables the references to the 5-year supply. The learned friend has identified those sentences which he will not rely upon. He's identified the table that he will rely upon in relation to 21-22, which follows that he's not going to rely on the remaining tables. It seems to me, just to assist you, sir, and I think to completely allay our concerns, if you were to set aside that note and the council in short order were able to produce a revised note removing those references, then I think that would be a sensible way forward, sir.
Okay. Mr. Williams, could that be done, and also could it be done fairly promptly as well? I mean, certainly by the time we move on to the second session today.
I would hope so, sir. As I understand it, Mr. Easton would be happy if we reproduce the same note but delete the final sentence of the third paragraph of the covering note. I understand that. And delete the final 1, 2, 3, 4, 5 columns on the attached table, and so that it's clear we are only seeking to rely on the monitoring year 21-22, which is that which Ms Banks gave evidence. I'm sure if that's what Ms Easton thinks is the right way forward, and I understand that position, that I'm just getting a note through saying yes, that can be done, sir.
Okay, Mr. Easton, would that alleviate your concerns?
I think it would, sir. I mean, the context for this is, I mean, we part of our job is to respond very quickly to detailed information, and I've done the best I can in the time available. It sounds to me like that would be appropriate. I haven't interrogated the tables. I've skimmed through the note, but I take it on trust from a learned friend that if that note can be produced, which only speaks to the 21-22 period and demonstrates the workings behind that, if that comes forward, I've no doubt that that's the correct approach. But I would need to look at that note when it came in, sir.
Yeah, that's absolutely. Okay, well, proceed on that basis. So I won't make this an inquiry document, Mr. Williams. Obviously, we'll await the submission of the revised notes by the time we start the second session today.
Understood, sir.
Okay, Mr. Williams, are there any other housekeeping matters?
Nothing for me, sir, no.
And Mr. Easton?
Only this, sir. I know that my learned friend has got it. I think I heard from the case officer that a list of documents we're likely to need during Miss Banks's cross-examination. I thought it'd be helpful to pass those on both to the council and to you, sir. Can I check you've got that list?
I have, Mr. Easton, yes. Mr. Williams, have you got that list as well?
I do, sir, yes, thank you.
And I think it's probably even more importantly, does Miss Banks have that list?
I did forward it to Miss Banks, I hope she does.
Right.
But I just wanted to check, yes.
Okay, thank you. Okay, well, Mr. Easton, you may now cross-examine Mrs. Banks.
Thank you very much. Is it Miss Banks or Mrs. Banks? And you're on mute, Miss Banks. So I didn't hear the answer to that, I'm afraid.
Yes, I am Mrs. It took me a long time to get there, but I am Mrs. Banks.
Okay, jolly good. Right, the first question should be relatively straightforward. You weren't the case officer for the application, were you?
No.
And do I take it that you were first involved after the appeal was submitted?
Yes.
Okay. I'd just like to narrow some of the issues down first of all. Could you take up, please, core document 3.3, which is the decision notice?
I'm done with it. Yes.
Thank you very much. Can we go to reason 2, please?
Yeah.
Reason 2 is an objection in relation to matters that the council say ought to have gone into a section 106 obligation.
Yes.
I think we can take this fairly quickly, can't we? Because all of the matters listed under reason for refusal 2 are now adequately addressed through the section 106 obligation.
Yes.
And so it follows that the objection set out in reason for refusal number 2 is now overcome, isn't it?
Yeah.
Thank you. Can we then go to reason 1? We'll go into this in a lot more detail in due course, but bearing in mind what you said in evidence in chief yesterday, can we just look, please, at the second sentence, which says the proposal would introduce 37 dwellings in the countryside where facilities and amenities are beyond reasonable and safe walking distance of the site.
Mm-hmm.
Can you confirm, please, that in relation to the safe walking distance point,
yeah,
the council is raising no concerns in relation to pedestrian safety? That's correct, isn't it?
It is correct, yes. It's more about the perception.
Thank you. Other matters which aren't at issue between us, there is the listed building Mill Lodge to the north of the site. Yeah. The council's position is that no harm would arise to that listed building through development in its setting. That's correct, isn't it?
That was the view of the Historic Buildings Advisor, yes.
Right, and you don't take a different view, do you?
No.
Okay,
I'm
thank you.
not qualified to do so.
No. Similarly, there's no allegation in relation to highway safety concerns in relation to vehicular traffic, is there?
No.
And no concerns or objections in relation to drainage or ecology, which couldn't be dealt with by way of conditions?
No, that's right, yes.
And so far as detailed design is concerned, if we just go back, please, to the first reason for refusal, we can see their reliance on the last paragraph of reason for refusal 1, reliance on policy RLP 90. I think as you very fairly explain in your proof of evidence, that's a detailed design matter. You no longer rely upon that policy.
That's right.
Thank you. All right, so that leaves us with the conclusion that the only matters which we need to discuss are those matters which remain in reason for refusal number 1.
Yeah.
Yeah. Now, so far as the approach is concerned, I'm sure we can agree this. The statutory requirement on a decision maker is to, first of all, consider whether development complies with the development plan taken as a whole.
Mm-hmm.
If the inspector concluded that the appeal scheme complied with the development plan taken as a whole, there would be a statutory presumption in favour of planning permission, wouldn't there?
Yes.
And so far as national policy is concerned, we can take it up if we like, but I'm sure you're familiar with it. Paragraph 11C of the NPPF explains that where an application complies with the development plan, consent should be granted without delay. That's correct, isn't it?
Yes.
Thank you. So far as the tilted planning balance is concerned, paragraph 11D of the framework, can we agree, please, what the triggers are for the tilted balance? I think it might just be useful, Mrs. Banks, if we take up the MPPF and go to paragraph 11.
Yeah.
You got it, good.
Mm-hmm.
And I'm not going to read it all out, but just so we've got in front of us, you're familiar with it, I'm sure we all are. One trigger is where the council is unable to demonstrate a deliverable supply of housing land.
Yes.
Yeah. And in those circumstances, the most important policies are deemed to be out of date and the tilted balance applies. That's correct, isn't it?
Yes.
Yeah. And if we look at the 11D, it also says where policy, the most important policies for determining the application are out of date.
Mm-hmm.
Now, setting aside 5-year supply for one moment, the approach is to consider first of all, to consider what the most important policies are.
Mm-hmm.
That's one, isn't it?
Yeah.
And in this case, do we agree that policy RLP of the earlier local plan, RLP2 of the earlier local plan, and CS5 of the core strategy are the most important policies?
Yes.
Okay. That must be right, because they're essentially at the heart of your case, aren't they?
Yeah.
Thank you. We then, the next stage is to determine individually whether the policies in question are out of date. That's step 2. And then finally, we form an overall judgment about whether they are collectively out of date. In other words, inconsistent with the framework.
Mm-hmm.
Right. Good. So if that final judgment leads to the conclusion that the most important policies are out of date because they're inconsistent with the framework, tilted balance will be triggered as well, wouldn't it?
Yes.
Thank you. It's also right, isn't it, that even if a decision maker concludes that the tilted balance isn't triggered by virtue of policies being out of date, their consistency with the framework is relevant to the weight that you would attach to them.
Yes.
Thank you. The next point, I'm dealing with the approach that we take, hopefully to assist the inspector. If there is any inconsistencies between policies in a development plan, it is the policy or policies that are the most recently adopted that take precedence.
Yes.
Yeah. And the final approach point is interpretation of policies. Whilst I appreciate it's a legal question, I'd just like your assistance as to how you've approached it, because I'm going to look at evidence in a moment. The interpretation of policies, one gives the meaning of policies their plain and ordinary meaning, read in their proper context.
Yes.
Yeah. The reason, justification, or the explanatory text that sometimes comes before or after policies doesn't form part of the policy itself, does it?
No.
So it may be relevant to the interpretation of policies, but it isn't policy.
No, that's right.
Similarly, the aims or objectives of development plans are not policies themselves. There may be an aid to interpretation, but they are not policies.
No.
Okay.
No, but they form the background as to how the policy's been arrived at, don't they?
Yes, they do. But the important distinction, Mrs. Banks, is that when one is considering compliance or otherwise with a development plan, it is the policies of the development plan that we are concerned with, not the reason, justification, or the aims or objectives. That's right, isn't it?
Yes, it is. Yeah.
Thank you very much. Okay, now can we next go, please, to the relevant development plan policies? I'm going to start off by looking at policy SP3 of the stage 1 local plan. And I find that in core document 4.3. And I'm going to, it's in fact one of those rare occasions where the PDF actually aligns with the page numbers of the actual document. So it's page 21. Now, to set the context, please, SP3 is part of an up-to-date development plan document for Braintree, isn't it?
Yes, it is.
Yeah. And in the decision notice, and we can go back to it if we like, but one of the policies which the council says is breached in by this development is policy SP3.
Yes.
Yeah. And so it follows from that, doesn't it, that so far as the council is concerned, SP3 is a relevant policy for development management purposes.
It's relevant in that it's a strategic policy that directs us as to where development should be in the stage 2 local plan, but it doesn't override the adopted plan because it is strategic. It's not there. It's not a development management policy as such.
Okay, well, we'll come on to whether that's right in a moment. But if it wasn't relevant to development management decisions, the council would not have relied upon it in the reason for refusal. That's right, isn't it?
Yes.
Yeah. Okay. Thank you. Now, in terms of the way in which we consider policy SP3, so policy. In terms of the way in which the development plan is proceeding, we've got the local plan part 1, of which SP3 is a part.
Mm-hmm.
There's the emerging local plan part 2,
mm-hmm.
Which inspectors have recently authorised made modifications consultation for. And going forward to the end of the plan period, is it 2033 is the end of the plan period? And the plan period for the local plan part 1 and part 2 is the same, isn't it?
Yes.
Yes. And so once the local plan part 2 is adopted, the local plan part 1 and local plan part 2 will operate together, won't they?
Yes.
Yes. And so policy SP3 will need to endure for the entirety of the plan period, won't it, up to 2033?
Yes.
It will also have to apply once the local plan part 2 has been adopted, with some amendments to settlement boundaries, to the amended settlement boundaries up to 2033, won't it?
Yes.
Yeah. Thank you. Can we look at then, please, at the wording of policy SP3?
Mm-hmm.
And it starts off by saying existing settlements will be the principal focus for additional growth across the North Essex Authorities area within the local plan period. Now, so far as existing settlements is concerned, as we sit here today, existing settlements are defined by reference to the settlement boundaries shown in the proposals map for the adopted local plan.
Yes.
Yes. That may change. In other words, those settlement boundaries may change, and in fact are likely to change once the local plan part 2 is adopted. That's also right, isn't it?
Yes.
Okay, so if we are to consider how policy SP3 is to apply, in order to understand whether a proposal is inside or outside a settlement boundary, we are to look to the proposals map in the first instance. That's how we understand whether in a settlement or not. Okay.
Yeah.
And then if we look at the second sentence, it says development will be accommodated within or adjoining settlements according to their scale, sustainability, etc. So if we want to know whether we are adjoining must mean next to the settlement boundaries as shown on the proposals map, as we've just agreed.
Mm-hmm.
Yes?
Yes.
Right. So subject to scale, sustainability and existing role of the settlement, subject to that, policy SP3 contemplates development adjoining existing settlement boundaries as shown in the development plan, doesn't it?
It does, but that's in the section 2 local plan.
It doesn't say that.
I know it doesn't say that, but it says further down about how local authorities in the group will be preparing their section 2 plans.
Okay. The current position. So if my client wanted to know the relationship with the appeal site to the existing settlement boundaries, they would look at the proposals map, wouldn't they?
Yes.
And High Garrett has its own settlement boundary in the adopted plan, doesn't it?
Yes.
And the appeal site is adjoining that settlement boundary, isn't it?
Well, it's on the other side of the road, yes.
So the answer to my question is yes.
Yes.
Okay. So if we look at the plain wording of the first paragraph, which is the policy part of the adopted development plan, subject to scale, sustainability, etc., but there is so far no breach caused by the appeal scheme to policy SP3, is there? Because it is adjoining a settlement boundary.
It would appear that way, yes.
Yeah. But we can also agree, can't we, that there's nothing in policy SP3 which states that it would only apply to future allocations in the Part 2 plan. Not constrained in that way, is it?
It doesn't specifically state it, no, but it's very clear that in section 2, we will be identifying our hierarchy of settlements.
Mm-hmm. Okay, are you looking at the third paragraph there, Mrs. Banks?
Yes, sorry.
Right.
Yes.
Okay, well, let's look at that together. In section 2 of its local plan, each local planning authority will identify a hierarchy of settlements where new development will be accommodated according to the role of the settlement, sustainability, its physical capacity and local needs. Now, what that says, I think quite sensibly, is that SP3 operates at the moment, but it recognises that one of the functions of the Part 2 plan is to reconsider and perhaps recalibrate the hierarchy of settlements in the individual North Essex authorities.
I'm not sure what you're getting at, sorry.
Okay, well, I should have said this at the beginning. I don't have the monopoly in asking really clever questions, Mrs. Banks. It's entirely possible that I'll ask a question that isn't clear or which you don't understand. Please don't do it with every single question, but if it doesn't make sense or you want me to repeat it, then feel free to do so. So I'm looking at the third paragraph and what that says, and well, let's break it down in the following way. So the section 2 will identify a hierarchy of settlements where new development will be accommodated according to set out there. Okay, so what that is saying is that through the Part 2 plan, and I know that Braintree are doing this in their Part 2 plan, they will look at the individual settlements within the district.
Yes.
And they will consider which of those settlements are perhaps the most appropriate to accommodate further growth.
Yes.
Yeah. Okay. And we know that the proposal is for High Garrett to be in, I think, a tier 3 settlement. And if the local plan Part 2 is adopted, that then has certain policy consequences.
Yes.
Yeah. Okay. But what paragraph 3 doesn't do is to exclude the application of policy SP3 until the section 2 local plan is adopted, does it? It's just signposting what is going to happen in the Part 2 plan.
Yes.
Okay. Thank you. Can we go then, please? So far, if we go back to the first paragraph, in the current circumstances, provided that scale, sustainability and the existing role of High Garrett are suitable to accommodate the appeal proposal, there is no breach of policy SP3, is there?
Not as such, no. But it'll then again be a judgment on in terms of whether or not we think the site is within a sustainable location.
Oh yes, I'm not trying to. I'm not.
Oh, sorry.
Yeah, forgive me. What I'm not suggesting, I will ask you questions about sustainable location.
Okay.
I'll ask you questions about character and appearance. I'm not suggesting for one moment, Mrs. Banks, that there is carte blanche if you're adjoining a settlement boundary, but I'm just trying to explore with you at the moment the way in which one approaches policy SP3. So that's very useful, thank you. Can we then go to the second paragraph, please? Future growth will be planned to ensure existing settlements maintain their distinctive character and role to avoid coalescence between them and to conserve their setting. Pause there for a second. So that would apply, wouldn't it, to development that is both within and adjoining settlements?
Yes.
Yeah. So one of the things, in order to bring oneself within policy SP3, even if you're adjoining a settlement boundary, is to consider the extent to which the development would harm the distinctive character and role of the settlement in question, or would lead to coalescence between individual settlements, as well as conserving their setting. Those are all, I suppose, landscape character and spatial questions that the inspector this inquiry will need to consider, aren't they?
Yeah.
Okay. Thank you very much. So in light of that, the next document is still on SP3, but I would like you to turn, please, to the Gilder Terrace appeal decision, which should be CD 6.2.
Okay.
You have it.
Yeah.
So that's a fairly recent decision, 27th of July this year, post adoption of the Part 1 local plan and SP3. Is that right? Yeah. And then if we go, please, if you scroll through or flick through, however you do it, to paragraph 53.
Yes.
The inspector there says there's clearly some tension between the strict confinement of development to within settlement boundaries by policy CS5 and RP2 and the more recent policy SP3, which accept further housing growth both within and around Braintree. However, decisions over any changes to these boundaries depend on the eventual adoption of a Part 2 plan. Policy SP3 doesn't provide a free rein to all proposals adjoining settlement boundaries. I'm pausing there for a second. Now that's a correct interpretation of policy SP3, isn't it? Because as we've just discussed, even if you're adjoining a settlement boundary, there are various other factors that you need to take into account before concluding there's compliance with SP3, such as coalescence, setting, sustainability, etc. So that's the inspector in the Gilder Terrace decision has properly understood the approach that you need to take when reading policy SP3. Yes?
Yes.
Thank you very much. Okay. Good. Now let's we're doing really well in terms of time. I'm going to ask you to look next, please, at policy RLP2, which is in core document 4.2. So it's if you're going by the PDF, it's page 13 of 150 or internal document 3 of 14. Do you have it, Mrs. Banks?
Yes, I do, yes.
Thank you. So RLP2 says new development will be confined to the areas within town development boundaries and village envelopes. Outside these areas, countryside policies will apply. In terms of the adopted local plan we're looking at the moment, all land outside settlement boundaries is deemed to be countryside, isn't it?
Yes.
Yeah. And that is the case irrespective of the sensitivity, the value of the landscape outside the settlement boundaries.
Yes.
Yeah. And outside these areas, countryside policies will apply. What does that mean?
It refers to policies later on in the local plan that seek to safeguard the countryside in terms of its, landscape, etc. The policies in the local plan were superseded upon the adoption of the core strategy.
Okay. That's so. The policy in the core strategy, which you say supersedes policy RLP2, must be CS5, mustn't it?
Yes.
Right. So does it follow then that you rely upon CS5 because it superseded policy RLP2?
RRP2 is still extant, but CS5, it's not that CS5 has replaced it. It's just that there were some policies in the original local plan that were struck out, but there are others that were still retained, such as RRP80.
Okay, so just so I understand, again, the purpose of my cross-examination is to assist the inspector, Mrs. Banks, is not to trip you up, to make sure that I've understood your evidence correctly. So where it says outside these areas, countryside policies will apply, countryside policy that we are applying in this case is policy CS5, is that right?
Yes, yes.
Okay, all right, thank you. Next, the next sentence says exceptions may be made to this policy for affordable housing schemes. Can I just ask you this question? If the appeal scheme were 100% affordable housing, would it comply with policy RLP2?
Possibly, but there would be other criteria that it would need to comply with before it could be considered compliant.
All right. And just before we leave policy RLP, I'd just like you, RLP2, I'd just like your confirmation of this point, please, that RLP2 and the countryside policies that flow from it, the same level of protection in policy terms to all land outside settlement boundaries, irrespective of their value or sensitivity.
Yes.
Yeah. Thank you. Now, can we go on to policy CS5 next, please? Which should be core document 4.1. And it's at page 65, but that's 67 of a PDF. Do you have it?
Almost. Bear with me.
That's right.
It's gone past. Oh, stop. I'm sorry about this. It's just gone mad.
That's right.
So sorry about this.
That's right.
There we go. Apologies for that. Sorry.
That's fine. You've got CS5.
Yeah.
It's quite a short policy. Outside town development boundaries, village envelopes and industrial development limits will be strictly controlled to uses appropriate to the countryside in order to protect and enhance the landscape character and biodiversity, geodiversity, etc.
Yeah.
Okay. So your case, as I understand it, is that because the appeal site sits outside the settlement boundary for High Garrett, it is automatically in conflict with policy CS5. I've understood that correctly, haven't I?
Yes.
Yeah. And I listened to your oral evidence yesterday, and you said that the appeal site is outside the settlement boundary and as such would fail to protect and enhance the countryside. Now, I took that to mean that your interpretation of policy CS5 is that any development outside the settlement boundary automatically fails to protect or enhance the landscape character of the area.
Yes, I think it's all part of the in principle objection of the policy.
Okay. And so it is genuinely an in principle objection rather than consideration of the sensitivity of the receiving landscape and the impact that the development would have on that landscape, isn't it?
Yes, it is. I mean, it slightly expands on RRP2 in that it gives a basic reason why we have the policy of restriction. Yeah.
Okay. And so just finally on CS5, the way that you say CS5 should be interpreted and applied is that there is automatic harm to countryside character where development is proposed outside settlement limits, irrespective of the site.
Yes.
Yeah. And so it follows from that, doesn't it, that policy CS5 throws a protective blanket across all land outside settlement boundaries.
It does, yes.
Now, so far as your case is concerned, do we, because RLP 2 effectively signposts the countryside policy CS5, that the considerations that the inspector would give to both of those policies will be exactly the same. There's no difference between them in terms of whether you say there is breach or compliance.
Not really, no.
Okay. Now, can we then, taking those policies together, we can agree, can't we, that the boundaries which CS5 and policy RLP2 seek to protect are unable to accommodate the levels of identified development needs, particularly for housing?
Yes.
And that must be right, because what the local planning authority has accepted is that those boundaries need to be updated.
Yes.
For a variety of reasons, perhaps the most important of which is to accommodate objectively assessed needs.
Yes.
Yeah? Okay. Thank you. All right, now in that, and I think you very fairly yesterday explained when you were telling Mr. Williams about the weight that you would attach to breaches of policy RLP2 and C5, you reduced that weight to moderate in recognition of the fact that those settlement boundaries are effectively out of date because they don't accommodate existing up-to-date needs.
Yes.
Yes. And so there's nothing between us about the principle of reducing the weight to conflict with policies RLP2 and CS5. I think it's just the amount of weight you reduce the conflict by.
Yeah.
Yeah. Okay. Thank you. Now, if you have the Gilder Terrace decision,
yeah,
okay, yeah, can we go back to that? Because the weight to be attached to policies RLP2 and CS5 was a matter that was considered there. And it's paragraph 54.
Yep.
Okay. The council acknowledges that the revised housing land supply positions relied upon the contributions made by a number of sites outside of development boundaries. Pause there. That's right, isn't it? And remains the case.
Yes.
Yeah. Okay. It's also correct to note, isn't it, and we might come on in a bit more detail later on, it's also right to observe that a proportion of the council's housing land supply relies upon the delivery of sites that were granted permission on appeal and which were outside settlement boundaries.
Yes.
Yeah. The Gladman scheme off Church Street is a good example of that.
Yes. Yes.
Yeah. All right. And then go back to paragraph 54. It then says, and that the restrictive nature of policies RLP2 and CS5 is not fully in accordance with the framework. Now that's something you agree with, and that's one of the reasons you reduce the weight to conflict with those policies, isn't it?
Yes.
Yeah. These development boundaries were evidently predicated upon much earlier levels of housing need dating back to 2001 and conceived many years prior to the publication of the 2012 framework. The conflict with policies RLP2 and CS5 over the site falling outside the settlement boundary is therefore given limited weight with the finding of a corresponding degree of limited harm. So we have an inspector there, I think, in terms of the factors that were taken into account in reducing the weight to policy RLP2 and CS5, we agree that all those factors are relevant to weight, aren't they?
Yes.
Yes. And that inspector concluded, having taken those factors into account, that conflict with policies RLP2 and CS5 should only be given limited weight.
Yes. Yes. That's
Okay.
what the inspector said. Yes.
Yeah. And that's an entirely reasonable judgment to reach, isn't it?
Yes.
Thank you. And let's think about this in a slightly different way. In circumstances where the settlement boundary policies RLP2 and CS5 are inconsistent with the national planning policy framework, one can reach the conclusion, can't one, that they are out of date by virtue of that inconsistency?
I don't think they're completely out of date because of their consistency. I mean, they have to be given less weight, but these two policies have been found to still be consistent by many inspectors, or still relevant, should I say, by many inspectors.
Yeah, now I'm not suggesting for one moment there's a difference. So that they are and remain policies in the adopted development plan. Yes. And so even if they are out of date because they are inconsistent with national policy, they would still remain policies of the development plan. They can't be set aside, can they?
No.
But that's a different consideration from whether or not they are, and we've agreed already they're the most important policy. That's a different consideration, isn't it?
Yes.
Including whether or not the tilted planning balance should be triggered by virtue of their out of datedness. You appreciate the distinction?
Yes.
Yes. And so I'm going to suggest that, particularly in light of the Gilder Terrace decision and the discussion we've been having this morning, this inspector would be entirely reasonable were he to conclude that RLP2 and CS5, being the most important policies, are out of date, and that the tilted planning balance should be triggered by virtue of that out of datedness.
Yes, he's entitled to think that. Yes.
Yeah, and you would agree with that judgment, wouldn't you?
More or less, yes.
Okay. Thank you. Next, can we take up your proof of evidence, please? And I'm going to ask you to turn, if you will, please, to page 26. And paragraph 7.2.
Yeah.
And in paragraph 7.2, you make reference to policy RLP2, and I assume you make the same point in relation to policy CS5, but about 5 lines down, you say that the application of that policy is not hindering the council in delivering housing growth within the district. You see that?
Yes.
Yeah, okay. I just wanted to benchmark that point. To explore that question a little further, can you take up, please, Mr. Dodd's proof? Mr. Dodd's proof.
Yeah.
Now, when you yes, go to page 13, please.
Yes.
At this point, I'm going to chastise Mr. Dodd for having quite small font, which requires me to put my reading glasses on. So, page 13, paragraph 416 says the council's current 5-year supply position also relies on homes which were initially refused by the council but were subsequently allowed an appeal. These include the following, which are claimed by the council to be deliverable. In the May position statement, I've set out the council's claim delivery in the 5-year period and the total site capacity. And then he lists a series of sites, the first one of which is land off Church Street, which is the Gladman decision, which we discussed a few minutes ago, Mrs. Banks, isn't it? So are you able to hear me?
Yes, I can. Yeah, sorry.
Yeah. So
Yeah.
so my
Yes, I said
question.
yes, sorry.
Yeah. So the first in the list, land off Church Street, 150 homes in the 5-year period. That is the Gladman scheme off Church Street, isn't it? Which we spoke about a few moments ago.
I think so. Yes.
Yeah. Okay. And we can go to the appeal decision itself, but that was a scheme which is in conflict with policy at RLP2 and CS5, wasn't it?
Yes.
Yeah. And then I don't know if you've had the opportunity, but I think it'd be right to assume, wouldn't it, that the most, if not all, of those sites listed under paragraph 416 by Mr. Dodd were greenfield sites and therefore by definition were in conflict with policies RLP2 and CS5.
Not all of them, no.
Right. Which one do you know which ones weren't?
51 to 57 Newland Street.
Okay.
83 Chapel Hill. I think.
Yeah. Was land off Western Road? That's the last one. 301.
That was Greenfield, yeah.
That was Greenfield, and so that would have been contrary to the to RLP2 and CS5, wouldn't it?
Yes, but it doesn't give the, if you don't mind me saying, it doesn't give the full picture in that the council has been following the call for sites, has identified many sites that are greenfield sites out of boundary and have moved them forward of the adoption of the local plan section 2 local plan.
Yeah, no, I'm sure that's right, because in order for that, and this goes back to the exchange we had probably about 10-15 minutes ago, that in order for the council to meet its development needs, it is going to have to release greenfield sites and amend settlement boundaries, isn't it?
Yes.
Yeah. But if we take, for example, the land off Western Road, which is 301 homes in the 5-year period, last one in the list, and land off Church Street, 150 homes in the 5-year period, that's 451 homes which have been granted on appeal contrary to RLP2 and CS5.
Yes.
Yeah. And so when you say that RLP2 and by extension CS5 is not hindering the council in delivering housing growth within the district, it's not quite right to say that, is it? Because the council expressly relies on appeal decisions where if the council's approach had been accepted, those sites would not have come forward.
No, but if you put in a position where an appeal has been allowed, then you can't ignore it, can you? You have to include it within your housing supply.
So you absolutely do, and I agree with that 100%, Mrs. Banks. But the point I'm making is a rather different one, and that's a response to your claim that policies RLP2 and CS5, and I think it must be assumed as applied by the council, are not hindering housing growth.
No, because certainly at the time the decision was made, the council, and still does, think we have a 5-year housing supply, plus the fact all the work that's being done on the stage 2 local plan.
Okay, but the 5-year supply is dependent, isn't it, to a fairly significant extent on the delivery of housing that has been granted on appeal, where the council resisted it due to conflict with policies RLP2 and CS5.
Yes, but some of those decisions go way back, don't they? And are, predate the publication. Some of them do, of the Section 2 local plan, and which sets out what the council's intentions are. It doesn't reflect the call for sites or the proactive role that the council has taken in identifying other sites. I mean, we have some, several large sites in the Section 2 local plan as allocations. Okay. And they identify where the strategic growth, we intend it to be. All
right. Well, let's just finish this little topic by what I hope will be a matter of agreement. The council, by virtue of the appeal decisions that are listed in most of the appeal decisions that are listed in Mr. Dodd's proof of evidence expressly rely upon proposals outside outside settlement boundaries and in conflict with RLP2 and CS5 in order to get to a 5-year supply, doesn't it?
Yes.
Yeah. All right. So next, please, can we briefly look at the emerging local plan part 2? I don't think we need to turn it up, frankly, because I can deal with it in this way. So the emerging local plan part 2 is not part of the adopted development plan yet.
No.
And it's right to note, as the National Planning Policy Framework sets out the circumstances where decision makers can give weight to policies in the emerging plan. And whatever else you might say, you wouldn't say that the emerging policies can be given full weight.
No.
Now, in terms of the part 2 plan, where we are at the moment is the inspectors have approved for consultation a number of main modifications.
Yes.
And I think the policy which I think is of most relevance for this inspector is policy LPP1.
Yes.
Which is very similar indeed, isn't it, to policy CS5?
Yes.
Yeah. And the main modification, as I understand it, is to change the wording from a reference to strict control of development in the countryside to confining those uses appropriate to the countryside.
Yes.
Why the, and as you said to Mr. Williams yesterday, you thought that was a change in language as opposed to a change in substance. Why the change in language, Mrs. Banks?
Well, because it's still seeking to direct development to within settlement boundaries.
Okay.
It's saying strictly. It's saying confined rather than strictly controlled. I mean, they're words, aren't they? I suppose confined is slightly more relaxed. You know, if you're looking at the strict meanings, but it still indicates to me that the council is seeking to direct development to defined settlements.
Okay, well, which is not an objectionable policy aim, but in terms of the changing of the wording, it would make no difference in your judgment, would it? To let's assume that policy LPP1 was adopted. The change from strict control to confinement wouldn't make any difference in this case to whether or not there's compliance or conflict, would it?
I don't think so, no.
Because I think, broadly speaking, confined and strictly controlled are not identical, but very similar, aren't they, in terms of what they're trying to do? Yeah. Okay. And so far as the consultation exercise is concerned, the representors, people interested in the local plan, will have an opportunity to make representations on the main modifications, including the wording change to policy LPP1, won't they?
Yes.
Yeah. And help with this. When does the consultation started, hasn't it?
Yes.
Yes. When is it due to be completed?
Hold on.
I imagine it's a 6-week consultation period.
I don't know off the top of my head, but I can find out.
Okay, not entirely necessary, but we are
Okay.
in consultation period at the moment, I think.
Yes.
Yeah. Yeah. Okay. And during that consultation period, representatives will be able to say whether or not they consider that the wording change to policy LPP1 is, amongst other things, consistent with national policy.
Yes.
Yeah. Which I think, as we agree, doesn't support strict control over all development outside settlement boundaries?
No.
Thank you. Right, I'm going to move on to accessibility next, but I just want to draw our discussion to a close in relation to I think what is the first issue, which is suitable location for development.
Mm-hmm.
And we've discussed the approach to policy SP3. If my client's scheme is compliant with policy SP3, it will be compliant with the most up-to-date development plan policy, won't it?
It would be, but
Yeah.
as we say, SP3 is a strategic policy.
I've been through that. Right. So accessibility next, sustainable location for development, which is one of the issues the inspector put in his note.
Mm-hmm.
Now, I want to understand, please, your evidence. Page 30 of your proof, please.
Mm-hmm.
So page 30, this is the section where you're identifying the adverse impacts of the proposal, and then paragraph 7.23, you summarise your position in relation to accessibility, and then over the page at the top, the last sentence, you say, for this reason, I attach significant weight to the site's unsustainability.
Yes.
What planning harm, Mrs. Banks, arises by virtue of your conclusion that the site is unsustainable?
Well, the planning harm is basically, in terms of sustainability, is that it goes against our policies in CS7, etc., and in the framework, which seek to provide obviously a choice of transport modes for people, but because of the location of the site relative to the nearest settlement and the larger sort of main settlement, if you're saying that it's something that can be easily accessed, within a few, it's not. It's a significant walk to the schools, more significant walk to the shops. In terms of cycling, it's admitted that only really experienced cyclists will be willing to tackle it. So therefore, whilst we accept there's a bus stop there, and that's fine, and in reality, we think people will still rely on the motor car.
All right. So the planning harm that would arise. So in answer to my question, the planning harm that would arise is your judgment that there will be conflict with local and national policy.
Yes.
I understood it correctly. Okay. Thank you. All right, now, so far as accessibility is concerned, Essex County Council are the highways authority for the area, aren't they?
Yes.
Yeah. And amongst their officers, there are expert highway engineers.
Yes.
And amongst their officers are experts in accessibility and sustainable modes of transport.
Mm-hmm.
Yeah. The County Council's Highways Authority didn't object to the scheme, did they?
No.
Can you take up then, please, Mr. Grist's appendices?
What's it done?
MPG2. MPG2.
Yep.
Okay, that should be a letter Yeah, dated 11th of January 2021 in relation to my client's scheme.
Yeah.
Yeah, right. And if we just go below where it says proposal, the emboldened paragraph says, having reviewed the information submitted with the planning application, the Highways Authority's position remains the same as it was for planning application, and there's a reference there. I'm pausing for a second to seek your confirmation that planning application 19/00, etc., is the application on land to the south of this appeal site, which is recently dismissed at appeal. Okay.
Yes.
And therefore, from a highway and transportation perspective, the impact of the proposal is acceptable to the Highway Authority, subject to the following requirements. And then the County Council recommend 4 conditions, don't they?
Yes.
All of which I think, in some form or other, have been incorporated into the conditions for this inquiry.
Yes.
Yeah. And I'd like you to look in particular, please, and in fact, it's the same reason, broadly speaking, for conditions 2, 3, and 4. So the condition 2, minimum 2 metre footway across the entire proposal site, A131 frontage.
Yes.
And that's going to be delivered as part of this appeal scheme, isn't it? But if we look, please, at the reason: to protect highway efficiency of movement and safety, and to ensure that the proposal site is accessible by more sustainable modes of transport, such as public transport, cycling and walking, in accordance with, and there's a reference to a number of the Highway Authority's development management policies.
Yes.
Okay, and then look at reason at condition 4, upgrading of 2 bus stops.
Yes.
An almost identical reason, isn't it, given there, sure the proposal is accessible by more sustainable modes of transport, such as public transport, etc.
Mm-hmm.
Okay. So in recommending that those conditions be imposed, the County Council plainly had in mind, didn't it, the accessibility of the location of the appeal site.
Yes.
Yeah. And it must follow, mustn't it, Mrs. Banks, that had they considered that the location was unsustainable, then they would have objected to the scheme.
I don't believe that they would, because they do not really comment. Although they look at it, you couldn't argue that the site is not accessible. I mean, it all relates to infrastructure. The site is off a main road. There is a bus route that goes through it. So highways are not going to say it's an unsustainable location. And whilst they're suggesting, they're recognising that the conditions, walking conditions on that side of the road are non-existent, they're recommending that a pavement is put there. That will only be, along the front of the site. That won't really change things in terms of the existing walking arrangements that are there. They're not going to object on highway safety grounds. They're not going to object on sustainability, because highway safety and issues like that can be overcome by conditions. And if planning permission is granted, we would be accepting of these conditions. But our argument is on a more practical level, in terms of making it easier for people to not have to rely on private transport.
Okay, well, that's a useful clarification, but you agreed a few moments ago, by reference to the reasons attached to the conditions recommended by the County Council, that the County Council plainly had the sustainability of the location in mind.
Yeah.
Yes. Now, can we just pick up that point and then go to CD 8.5, please, which is the consultation response in relation to land to the south, remembering that the letter we've just had a look at, Mr. Grist's appendices, says that they take the same view about my client's site as they did in land to the south. So if you have 8.5, and there says, with the framework in mind, particularly paragraph 32, highway authorities review the planning application supporting transport statement against its own development management policies to ensure the proposal site can be accessed safely. Any additional trips will not be detrimental to highway safety and capacity, and to ensure, so far as possible, The proposal site is accessible by more sustainable modes of transport, such as public transport, cycling, and and then we need to get to any of the specific wording in the rest of that section. We can do, but we can note that there was a site visit, the proposal site. You can see about 6 lines down, and then therefore at the end on the top of this bottom of this page, therefore from a highway and transportation study, the impact of the proposal is acceptable to the highway authority subject to the following requirements, and there are a series of conditions, a number of which are very similar, if not identical, to the conditions that we've had a look at in relation to the appeal site.
Yes.
Yeah, okay. So the overall position must be this, mustn't it, Mrs. Banks, that the expert officers from the County Council considered the sustainability of the location of both the appeal site to the south, the appeal and my client's site, and reached the conclusion that there was no basis on which to object on sustainability grounds.
That would be looking by referring to their own standards. How, I mean, they can't. If there's a footpath there, if there's a bus there, if there's a road there, you know, all these things, you know, can be made acceptable. However, our objection is not that it's unsafe on highway grounds, that it's not impossible to walk or to catch a bus. The main factor is the actual distance to the day-to-day facilities that residents would need here, and the likelihood of them perhaps using public transport, particularly, you know, in the winter or in inclement weather, because of the distance to necessary facilities. It's just too far to expect people to walk.
All right, so
and they wouldn't, especially if you look at the IHT guidelines in terms of, you know, what are acceptable and desirable distances.
Yeah, can we summarise the position in this way then, so that you on behalf of the council reach a different judgment about the sustainability of the location from the judgment reached by the expert officers of the county council?
Yes, but we're entitled to do that.
Oh, you are?
Yeah.
You are, of course you are. All right, now in terms of policy, can we agree please that the national policy requirements in relation to the sustainability of locations for development are not materially different from those in the development plan?
No.
Right. I just wanted to short circuit things. So if there is compliance with national policy, there will also be compliance with local policy. There's no real difference between the two, is there?
There shouldn't be, no.
Okay, all right. In that regard then, can we look please to, so I should have said as well, Mrs. Banks, if at any point during cross-examination you need a break, please let me know. It's not an endurance test. All right.
Okay, thank you.
Just to like actually point, Mr. Easton, I will probably intend to break around 11 o'clock for 30 minutes. So if that's of use in terms of your examination, cross-examination.
Yeah. So what I'm hoping to do is to finish accessibility, and that will probably take about another 20 minutes, which might take us slightly over.
Okay, fine.
Over 11 o'clock, but I'll certainly bear that in mind. Thank you. So National Planning Policy Framework, please, Mrs. Banks. And I would like you to go to paragraph 105 first of all.
Yes.
Paragraph 105. Planning systems should actively manage patterns of growth in support of these objectives, which are set out in the preceding paragraph. Significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes. Pause there for a second. So the objective, I think, is not to eliminate reliance upon the internal combustion engine private car. It's to offer a genuine choice of sustainable transport modes. That's the policy objective, isn't it?
Yes.
Yes, thank you. This can help to reduce congestion and emissions and improve air quality and public health. Pause there for a second. Now, in terms of I think the underlying objective of this section of national policy, it is essentially to reduce environmental effects, reduce carbon emissions, and avoid adverse impacts on public health. That's the rationale, isn't it? Yeah. Okay. And so development which provides opportunities to achieve these objectives, reducing environmental effects, reducing carbon emissions, and avoiding adverse impacts on public health by virtue of in relation to travel, would be complying with those objectives, wouldn't it?
Yes.
Yeah. Okay. Thank you. So, and then paragraph 105 carries on. However, opportunities to maximise sustainable transport solutions will vary between urban and rural areas, and this should be taken into account in both plan making and decision taking.
Yes.
And I think that's really a recognition, isn't it, of the fact that it would not be reasonable to expect a level of bus service in the countryside that was akin to the level of bus service you might have in central London.
No.
As an extreme example. Okay. And so the level of sustainability, the level of access to sustainable modes of transport will be settlement and site specific, won't it?
Yes.
Yeah, thank you. And then can we go on, please, to paragraph 110?
Yeah.
110, in assessing sites that may have been allocated for development in plans or specific applications for development, that's the one we're concerned with here, should be ensured that appropriate opportunities to promote sustainable transport modes can be or have been taken up, given the type of development and its location. So the appropriate opportunities to promote sustainable transport modes is extremely similar, isn't it, to the discussion we've just had, which is provide opportunities for people to use sustainable transport modes rather than the internal combustion private car. Yeah. And paragraph 110 applies to any development irrespective of its size, doesn't it?
Yes.
Yeah. Thank you. Now, bearing in mind that we just discussed the opportunities to reduce travel, reduce carbon emissions and environmental impacts, can we go in the framework, please, to the glossary?
Yeah.
The glossary, and I'd like you to go to the definition of sustainable transport modes, which, if you've got a paginated version of the framework, is at page 73.
Yeah.
Sustainable transport modes: any efficient, safe and accessible means of transport with overall low impact on the environment, including walking and cycling, which we'll come on to look at, ultra low and zero emission vehicles, car sharing and public transport. Now, so far as zero emission vehicles are concerned, that's a sustainable mode of transport, and a condition requiring the provision of electric vehicle charging infrastructure with the appeal scheme will help to facilitate a sustainable mode of transport, won't it?
Yes, it will, but it won't overcome our overall objection in terms of the walking distance to accessing day-to-day needs.
Okay. Well, a couple of points emerge out of that answer. First of all, you haven't considered the offer to provide electric vehicle charging infrastructure in your proof of evidence, have you?
No.
No. Okay. Second point is that we can agree, can't we, that the objective of national policy is to provide opportunities to use sustainable modes of transport. Now, that requires a holistic judgment by the decision maker, considering all types of sustainable transport modes, doesn't it?
Yes.
Yes. And so it wouldn't be right to say that the provision of electric vehicle charging infrastructure is not enough because it doesn't overcome concerns about walking distances. The electric vehicle charging infrastructure ought to be taken into account as part of the overall judgment about sustainability, shouldn't it?
Yes.
Yeah.
Yes.
Okay.
But I don't think it overrides, other concerns completely, because it's not really taking away the problem of relying on a vehicle rather than walking or catching a bus.
Yeah, but the objective, I think we'll go just remind ourselves of the discussion we had. In national policy terms, of course, walking is a sustainable mode of transport. Of course it is, and that's in the definition. But the objective is to provide opportunities for people to use sustainable transport modes.
Yes.
And to the extent that electric vehicle charging infrastructure is going to be part of my client's scheme, it meets that objective, doesn't it?
Yes.
Yeah. Okay. And then the next type of sustainable transport mode is car sharing. Now, car sharing is a matter that can be encouraged through the adoption and implementation of a travel plan, isn't it?
Yes.
Right. And so to that extent, a condition requiring a travel plan, which is likely to include measures to encourage car sharing, is supporting and is consistent with national policy, isn't it?
Yeah.
Right. You didn't include car sharing or the effect of a travel plan in your proof of evidence, I don't think. Do you?
No.
No. All right. Right. Now let's consider the sustainable transport modes that you have addressed in your proof of evidence: walking, cycling, and public transport. There are essentially two aspects to the assessment. There's the quantitative assessment, which in simple terms is how far is it to the shop, how far is it to the bus stop, and then there's the qualitative aspect, so the quality of the pedestrian links, the suitability of the road for cyclists, any barriers to use. That's the qualitative aspect. Okay. And I think we've also just agreed, haven't we, that in terms of policy compliance, an overall judgment is required, taking into account all of the opportunities which may be available to access sustainable transport modes. Yeah. Right. Well, let's deal with bus first of all. You provide us with a very concise assessment at your paragraph 426. We go to your paragraph 426, please. Page 19.
Yeah.
My reading of your position in relation to bus travel is that it is a qualitative concern. In other words, it's the likelihood that people are going to cross the road to catch southbound buses into Braintree and Bocking. That's your concern.
Yeah.
Yeah. Now, can we agree this though, that in general, there are 3 buses per hour from the bus stops closest to the appeal site?
Yes.
And that it takes about 9 minutes to get into Braintree and 3 to 4 minutes to Bocking.
Yeah.
Yeah. And there are bus stops on the site frontage.
Yes.
And as part of this scheme, there'll be improvements to the bus stops to make it more attractive for users.
Yes.
And as part of this scheme, there will also be improvements to pedestrian crossings across the provision of a pedestrian crossing across the A131. Yeah. Okay. So in quantitative terms, we can agree, can't we, that the bus stops are very close to the appeal site?
Yes.
We can agree, can't we, that having regard to the frequency of service, there is a good level of bus service which future residents can use?
Yes.
Yeah. And we can also agree that the upgrade to the bus stops will benefit not only future residents of the appeal site, but existing residents of the area who want to use the bus.
It could do, yes.
Similarly, the provision of a pedestrian crossing will be of benefit to future residents of the appeal site who would want to use the bus, equally benefit to existing residents who want to cross the road to access the bus.
Potentially.
Yeah, all right. And so the only issue in relation to the bus is the likelihood that you say people would cross the A131, notwithstanding. Well, pause there for a second. In your proof of evidence, unless I've missed it, I don't think that you have considered the the measures to improve pedestrian infrastructure, the crossing across the A131, have you?
No, but they are. What can I say? Although that the county council has requested it as a condition, that is without the benefit of any analysis as to whether or not such a crossing could be carried out. Certainly with a pedestrian island in the middle, there's a possibility that may not happen. Certainly you could have, the textured paving on either side of the road, but you've still then got to get, if you haven't got a pedestrian island, you've got to cross the road in one fell swoop.
Right. The county council, we know that they visited the area because we saw their consultation response in relation to Land of the South, which they said they had visited the area. It is unlikely, isn't it, that the county council would have recommended the pedestrian infrastructure crossing the A131 in circumstances where that was not feasibly achievable?
No.
Yeah. Okay. We can also note, can't we, that there are some bus stops, the Grove Fields bus stops with dropped curbs, I think some 300 metres to the south of the Hare and Hounds Club.
Yeah.
They were implemented within the last few years.
Yes.
Yeah. If they were unsafe, then it's unlikely, isn't it, that they were not going to be used. It's unlikely that they would have been provided.
Oh, yes. I mean, we're not saying it's a safety issue.
Okay. Well, the other bit I said is unlikely to be used.
Yeah.
So if they're unlikely to be used, I think it's unlikely that the county council would have installed those pedestrian pieces of pedestrian infrastructure, isn't it?
I don't think they can say that. I think they're all about facilitating, and it's one thing facilitating things to enable people to do what you want them to do and behave in a way that you want to behave, but it's another thing for them to actually do so. You can't control what choices people will make. Right.
So I think in terms of bus stops, I think notwithstanding the improvements to the bus stops and the pedestrian infrastructure, it is your, again, I don't mean this pejoratively, Mrs. Banks, but it's your subjective judgment about the likelihood that people are going to cross the road to access the southbound bus.
Mm-hmm.
That's what it comes down to in terms of public transport.
Yeah.
Okay. By the same token, and I appreciate that people might not be coming from the appeal site and travelling north in the same numbers as people travelling south towards Braintree, but you can have no concerns, can you, about people accessing northbound bus services?
No.
No.
We're not saying that we have.
And you mentioned on a number of occasions in your evidence in chief a scenario where people were trying to cross the road with one or possibly more children, but the A131 is not an absolute barrier. Even if you're right about people with children, it wouldn't necessarily be, in fact, it'd be unlikely to be a barrier to people who want to get the bus to work in Braintree.
It's not a barrier, no, but it's the convenience. For instance, travelling in a bus takes a lot longer than it would to drive your car to your place of work, because you would go directly there. On a bus, you have to call at all the bus stops.
Okay, so right, I understand that. So you say it is unlikely that people would access a sustainable mode of transport, notwithstanding the fact it takes 9 minutes to get into Braintree, because most people prefer to use the car.
Yeah.
Right. So by continuing that approach, Mrs. Banks, it would mean that even if there were a signal controlled crossing provided by my client, so that there was no impediment to crossing the A131, because your view is that people would generally not prefer to use the bus because it stops at lots of bus stops, you'd still be making the same point, wouldn't you?
More or less, yes.
Yeah. Okay. So your judgment then is that it sort of doesn't matter how sustainable how accessible a site is to public transport, people will always prefer to use the car in comparison to getting the bus from this site. That's your view, isn't it?
More or less, yes. I mean, we're not saying that nobody will. We're just thinking that it's based on human nature and people's circumstances, people with young families, etc. The type of people that might live in such a location would invariably prefer to use the car.
Yeah, but isn't that fundamentally at odds with national policy, which is meant to encourage people, encourage developers to locate sites that provide the opportunities to use sustainable modes of transport?
You could see it that way, but because of the nature of High Garrett and where it is, it's not like it's within a town as such. It's a sort of a semi, you've got a semi-rural area. It's just that I cannot foresee that people will choose to catch a bus or walk to the co-op from that site. They would rather get in their vehicle and drive down there.
All right, thank you.
Because of the nature of everyday life. I understand that is at odds, and these policies are, the government and everybody is seeking to encourage this. But I think for us, if we are going to develop on the west side of the road at some point, then there needs to be more done in terms of, there's no infrastructure there in terms of people being able to access everyday facilities.
Right, okay.
I'm not saying that people aren't willing to travel, but it's just a particular nuance of that part of the district.
Yeah, all right. So it's got to 11 o'clock. I'm not making as quick progress as I thought I might be. If it's convenient to you, sir, now might be a time to break.
Okay, how much further have you got to go in terms of this accessibility to services issue? Just roughly, Mr. Easton, how would you say? Ballpark?
10, 15 minutes.
10, 15 minutes. Okay, we will break now then. So the time is 11:02. Mrs. Banks, as you aware, obviously you're still giving evidence. You need to avoid communicating with your advocates during the adjournment.
Yeah.
Mr. Williams, you have your hand raised.
Thank you, sir. The amended note on affordable housing, as per our discussion earlier, has been circulated. So hopefully Mr. Easton will be able to see that, and hopefully he won't have any objection to the amended version of it.
Okay, well, we'll deal with that when we resume. We'll resume at 11:30. Thank you.
Thank you very much.
Thank you.
Mrs. Banks, so you're still unmuted and your camera's still on. Just
time is now 11:30 and I shall resume the inquiry. Just before you continue with your cross-examination, Mr. Easton, I have received the council's affordable housing notes during the course of the first session. Have you also received that document?
I have, sir, yes.
Okay. Well, my intention would be to put out an inquiry document, and I'll call that inquiry document 8. Okay. Thank you. Thank you. Mr. Easton, do you please resume?
I do. So can I just mention?
Yeah.
I'm going to ask Mrs. Banks a couple of questions about affordable housing, but I'm not going to interrogate the note. What I'm going to do is to the extent that I need to deal with it in any detail, I'll deal with it through Mr. Murray Cox.
Okay. Thank you.
Right. Okay, Mrs. Banks, we'd looked at getting the bus. Now, cycling. The position that the appellant's expert has adopted is that confident cyclists are likely to use the road network. I don't think you disagree with that, but your view is that as an alternative to the private car, it's unlikely to get many people out of their car onto the bike. Is that a fair summation?
Yes.
Okay. Now, so far as but the fact that let's assume that people cycling to work or for other journeys broadly reflects the percentage of travel to work journeys by bike, which is 2% in the Bocking North Ward, if planning permission is granted. One ought not to discount that possibility from our overall holistic judgment about sustainability of location, should one?
No, and we haven't. We just said what we said.
Okay, thank you. Now, walking, please. That the number and distance to services and facilities, both in High Garrett and Bocking, is a matter of agreement, isn't it? Because there's the appendices to the Statement of Common Ground.
Yes.
Okay. And so far as distances are concerned, you have referred in your evidence to how far people walk, the 2015 document, and to the IHT guidelines.
Yes.
Yeah. And as I understand it, that they are the only pieces of guidance that you have taken into account in your writing your evidence.
Well, I have, because they're the documents referred to by the appellant. And I've also taken account of the evidence that the appellant put in.
Right. Can we agree this, please, so far as the IHT document, how far do people walk, and as we'll come on to look at in a moment, manual for streets, they were all the guidance documents as opposed to statutes or firm pieces of policy.
Yes.
Yeah. And we can also agree, can't we, that insofar as any of them refer to distances, let's say, for example, an 800-metre walking distance, we aren't to assume when looking at that guidance that people will walk 800 metres and then suddenly stop.
No, of course not.
No. Okay. Thank you. Good. Can we take up, please, Manual for Streets, which is core document 8.8.
Yep.
And are you looking at on a PDF, Mrs. Banks?
Yes.
Yeah, so it should say page 46 of 146 is where I'd like to go to, please. And I'm looking for section 4.4.
Yep.
4.4.1 says walkable neighbourhoods are typically characterised by having a range of facilities within 10 minutes walking distance of residential areas, which residents may access comfortably on foot. However, this isn't an upper limit, a point I think we agree on. And PPS 13, which I think should be PPG 13 states that walking offers the greatest potential to replace short car trips, particularly those under 2 kilometres.
Yes.
Okay. Now, I'm no doubt you're familiar with the guidance in PPG 13 about 2 kilometres being the distance that offers the greatest potential to replace short car trips. And so in that sense, 2 kilometres has a certain significance, doesn't it? Because 2 kilometres is one of the distances that we need to take into account in order to judge whether or not there is that potential to replace short car trips.
Yeah.
Yeah. And to the extent that 2 kilometres is a relevant metric, we can agree, can't we, that all of the services and facilities, including the local primary school, are within the 2 kilometre walk distance.
Yes.
Yeah.
I think the co-op's just slightly above.
Is it? Now, yes.
Or thereabouts. Yeah.
Yeah, 2,200. Well, I've got 2.2 on here. Right, so co-op's slightly above. But everything else is within the 2 kilometre walk distance, which, by a measure which is recognised in national policy and practice, is a distance which has the greatest potential to replace short car trips. Yeah. So good, thank you. And then can we look, please, at CD 8.7, which is the IHT guidance. And if you go to page 12 of 25 in the PDF, or internal page 49, I note that what you've done in your proof of evidence, and if we need a reference, it's at page 15.
Yeah.
You've extracted the table, but what you haven't done, Mrs. Banks, is to reproduce the heading. Table 3.2 on the HT guideline says suggested acceptable walking distance. And so the way to read that table is that any of those distances are acceptable walking distances. It may be that some are more acceptable than others.
Yes.
But they're all subsets.
Yes.
And so when, for example, at paragraph 415 of your proof, you say the primary school is well above the acceptable distance and almost at the preferred maximum, and then lead to the conclusion that it's not within a reasonable walking distance on a day-to-day basis. I'm afraid to say that's based on a misreading of the table, because all of the distances within table 3.2 are acceptable, aren't they?
Well, why does it say then on the bottom row preferred maximum? Sorry, yes, I see what you mean. Yes.
Yeah, so they're all subsets of acceptable, aren't they? But of course, it would be more sustainable if a school were 500 metres from a site. But what the IHT guidance is telling us is that if a school is within 2,000 metres, I'm using school as an example, if the school is within 2,000 metres of a site, that is still within the range of acceptable distances. That's how you read the table, isn't it?
Yes.
Right. And so when you conclude that Bocking is not within a reasonable walking distance on a day-to-day basis, at least so far as schools are concerned, that's not right, is it? If you're using the table.
I wouldn't be specifically referring to the table. That is the council's opinion. Obviously, the appellant has referred to that, but in our view, it's not a reasonable walking distance, and that's been backed up by the appeal to the south of the site.
Yeah, hang on
I say
there,
perhaps reasonable is the wrong word. Perhaps it's an unlikely distance that people would be prepared to walk every day, twice a day.
All right, this is an important point. Let's go back. Let's go to your proof, page 15.
Yeah.
And then you've got the table, the IHT table without the heading at the top of the page. And then at paragraph 415, you say, however, if applying the IHT guidance, the primary school is well above the acceptable distance and almost at the preferred maximum. What you have said, what you say in terms, is that you are judging the acceptability of the distance to the school by reference to the IHT guidance, aren't you?
Yes, in a way, yes.
Yeah. Well, not in a way, explicitly.
Okay.
So if your evidence is based on a misreading of the IHT guidance, which you have expressly applied, then it inevitably follows that the conclusion you've reached relying upon the IHT guidance must be flawed, mustn't it?
No, because I think what we've looked at is what is desirable, and then the desirable and acceptable distances, and seeing the 2,000 meters as a preferred maximum. But based on the it's not just about the distance. As I go on to further in my proof, it's about the perception, or sorry, not the perception. It's about the practicality of people from the site choosing to walk to school, having to cross the road several times before they get into Church Street. It would take them half an hour, just a single person walking by themselves. That's the point we're trying to make.
All right, forgive me, Mrs. Banks, but what I tried to do at the beginning of this section of cross-examination is, and I thought you agreed with it, that there are essentially two aspects to walking in particular. There's the quantitative aspect, which is how far is it, and there's the qualitative, which is the quality of the links, any impediments to getting there.
Yeah.
And a really good example of that is it's entirely possible that you have a site that is within 500 meters of a town centre, but if you have to cross a dual carriageway to get there, it sort of doesn't matter that it's that close, because crossing a dual carriageway is going to be a huge impediment. That's the qualitative aspect.
Yes.
Okay. Now, what I've rather understood your paragraph 415 and that section to be looking at is your quantitative assessment. In other words, in terms of distances, is this within an appropriate or acceptable walking distance? And I'm suggesting to you, and I think the point's pretty clear by now, that your quantitative assessment is based on a misreading of the guidance you're trying to rely upon. That's right, isn't it?
Yes, okay.
All right. And the other point just to note is that you hadn't taken account, had you, of the guidance in Manual for Streets, which cross-refers to PBG 13, mentioning the 2 kilometre distance as being the distance that has the most potential to replace private car trips. That's not something you had regard to.
No, well, only in the round. I didn't mention it specifically.
No, okay. Thank you. Well, let's look then, please, at your qualitative concerns, and I think you summarised those at paragraph 417 of your proof, page 16. And you refer to the intimidating nature of the road, and then I think 5 lines down there are a series of factors you take into account. So first of all, the narrowness of the pavement. In terms of the narrowness of the pavement, would you take up, please, Mr. Grist's proof? And would you go, please, to page 17 of his proof? And paragraph 5.3.24. Just let me know when you're there, Mrs. Banks.
Oh, I got the right document. Hold on. Sorry, it's doing a funny again. Bear with me.
That's all right.
You're talking about his proof, yes?
His proof, yes, please.
Yep. It must be the wrong document. Yes, which paragraph, sorry?
5.3.24 at page 17. Should start, I've walked the continuous footway.
Yep.
Yeah, so I've walked the continuous footway along the A131 undertaken measurements along its length. The footway varies in width, but it's generally 1.7 to 2.4 metres wide. For large sections, it also has verges along the footway that can be used as extra width when required. Now that's correct, isn't it?
Yes, up to a point, yes.
Well, and then, so have you measured the width to justify your conclusion that the pavement's narrow, Mrs. Banks?
No.
No. And then, importantly, at 5.3.25, Mr. Griss makes reference to the Department for Transport's inclusive mobility document, which talks about a clear width of 2,000 millimetres, allows two wheelchairs to pass one another comfortably. And then, where this isn't possible because of physical constraints, 1,500 millimetres could be regarded as a minimum acceptable in most circumstances. And so he concludes, I think rightly you'll agree, that the footway width is entirely acceptable, even having regard to the Department for Transport's document, which is focused on people with mobility issues.
Yes, but
right,
it may meet the standards set out in those documents, but the practicality of walking that pavement with a wheelchair or a pushchair or what have you would not be attractive. Excuse me.
Yeah, I'm going through the factors which lead you to the conclusion that the route would be very intimidating. The first factor is the narrowness of the pavement.
Yeah.
That can't be a factor having regard to the discussion we've just had, can we? Can it?
No, not if you're looking at it from that point of view, no.
No. The next factor is the amount and speed of the traffic. Now, so far as that is concerned, you can confirm, can't you, that there is no evidence of personal injury accidents involving pedestrians, which the inspector ought to take account of in determining the attractiveness or otherwise of the route.
No.
No. Okay, and in terms of the speed of the traffic, now the A131 is an arterial route into Braintree with a 40-mile-an-hour speed limit. There is nothing unusual or exceptionally busy about the A131 in comparison to other such similar routes, is there? It's nothing out of the ordinary.
It's probably not anything out of the ordinary, no, but yeah, go on, carry on.
Okay, no, that was my question. That's helpful. And then the next point you make is the noise. Pause there for a second. There was a noise assessment which supported the planning application, but there's no noise objection relating to traffic in relation to this development, is there?
No.
No. More particularly, there is no noise objection which references any adverse public health consequences of people who would be using the footways close to and in the environments of the appeal site.
No.
No. And then fumes. The A131 along this stretch is not an air quality management area, is it?
Not as far as I'm aware.
No. And the council didn't ask my client to produce any air quality assessment, did it? One thing you did mention in your evidence in chief about footways, apart from the width, which we've now dealt with, was the did I understand you correctly to say you thought some of the footways were in a poor state of repair?
Yes, they are. The surface is coming away.
Okay. Now, the Highways Authority, Essex County Council have repairing and maintenance obligations as a Highways Authority, don't they, in relation to pavements?
Yes.
Yeah. We have to assume, for the purposes of this inquiry, that the Highways Authority will meet their statutory obligations to keep those pavements in repair, don't we?
One would hope so.
Well, we have to proceed on that basis, don't we,
Yes.
Mrs. Banks? Thank you very much. Thank you. Last point on accessibility. If you've still got Mr. Garrett's proof to hand, would you scroll or move forward, please, to page 36? And it's section 7, and it says nearby permitted residential developments.
Yeah.
All right. Now, I mean, can I just check? You've read Mr. Grist's proof, have you?
Yes.
And so what he says in relation to the location, the number, and the comments from delegated from officers' reports about the 3 sites he draws our attention to, all of that is accurate, isn't it?
Yes.
Yeah, thank you. And I have no doubt whatsoever that when, for example, if we look at paragraph 7.22, where Mr. Grist refers to the delegated report, which reaches a conclusion that the site is in a fairly sustainable location, as it's well served by public transport with an easy reach of Braintree, booking its services, education, and employment opportunities, that the officer who wrote that report had firmly in mind both local and national policy in relation to the sustainability of locating development.
Yes.
Yeah, okay. And as we agreed earlier on, although paragraph 105 of the framework does make reference to significant development, paragraph 110, and please tell me if you'd like to go back to it, paragraph 110, let's just, again, I don't want to catch you out, Mrs. Banks. Let's go back to the MPPF.
Yeah.
And go to paragraph 110. And you recall that when considering specific applications for development should be ensured that appropriate opportunities to promote sustainable transport modes can be and have been taken up given the type of development and its location. Now, you agreed, I think quite rightly, that would apply to any type of development, irrespective of its size.
Yes.
And so I think when that particular officer reached a conclusion that the land between 1992 High Garrett was in a fairly sustainable location, he or she had firmly in mind that particular policy objective. I
believe so. But it would have been, at the time the decision was made, it would have been a different version of the MPPF, so I can't remember that far back, but yes, they would have had that in mind. Yeah,
well, one thing that certainly happened, and for my part, Mrs. Banks, is quite frustrating, is that although a lot of the policies haven't changed, the paragraph numbers have had.
Yes.
So I've had to memorise lots of different paragraph numbers, albeit that the policies stay the same. But I think you can agree, can't you, that the national policy, which requires appropriate opportunities to promote sustainable transport modes, have been or can be taken up, hasn't really changed since the 2012 framework.
No, I would agree with that.
Yeah. All right. And then if we look, for example, at paragraph 7.3.2, forgive me. There's a reference to Trotter's Rest sites located within walking distance of High Garrett, location of several public transport links to nearby towns and villages. As was established with planning permissions granted for 2 detached dwellings in 2017, site is considered relatively sustainable. Now, I mean, you're aware, aren't you, about the principle of consistency in decision making?
Yes.
Yeah. And when the council considered and formed a view having regard to national policy about the sustainability of the 3 schemes that Mr. Griss mentions in section 7, they expressed a view that each of those sites within High Garrett were either fairly or relatively sustainable.
Yes.
Didn't they? And all of them were granted planning permission, so therefore any deficiencies in sustainability obviously weren't so significant as to justify the refusal of planning permission. Yeah. And in relation to this appeal, the inspector ought to take into account the approach that the council has taken with respect to other proposals in High Garrett, oughtn't he?
Yes, but every application has to be judged on its individual merits.
Yeah, but one of your principle that's as a generality, I agree. But one of the points you make in your proof on, and you mentioned yesterday, Mrs. Banks, is that High Garrett as a settlement is not a sustainable location for further growth. And so to understand whether that has consistently been the council's position, it is relevant to take into account the council's consideration of other schemes within High Garrett and their view about the sustainability of those locations, isn't it?
Yes.
Yeah. And so if the inspector takes that into account, he will be able to see, albeit I accept that the council did object on sustainability grounds to land to the south, he'll be able to see that there are 3 occasions where the local planning authority considered that High Garrett was a sufficiently sustainable location for further housing development, won't it?
Yes.
Okay. Thank you very much. Right, let's move on to the penultimate topic, which is landscape and visual. You are entitled, before I ask these questions, Mrs. Banks, you are entitled, as a qualified and experienced planner, to form a judgment about landscape and visual impacts. I completely accept that. But you don't have any specific landscape qualifications, do you?
No.
No. Similarly, there were no objections to this proposal from the local planning authority's landscape services department, was there?
That's right, yes.
Yeah. And there weren't, and you don't raise any methodological criticisms of the landscape and visual appraisal that was produced by Tyler Grange as part of the planning application.
That's correct.
Yeah. And you have seen Mrs. Brockhurst's photo montages, I have no doubt. Yeah. And you don't, you didn't yesterday, and I don't think you do now, raise any technical criticism of the photo montages and what they show.
No.
Okay. And you haven't carried out any transparent or objective assessment of the landscape character or visual amenity impacts of this proposed development based on the guidance for landscape and visual impact appraisals produced by the Landscape Institute, have you? No. No. Now, can we then see what you do say, your planner's judgment about the value of the site? And go to paragraph 5.8 of your proof, first of all. Where you say that the page 22, the western side of the A131 within High Garrett has a very different character to the eastern side. Then you go on to explain in your view the differences. But you say there, western side of the A131 within High Garrett, and so I take you to mean from that expression that the appeal site is within High Garrett, albeit that it has I think you explained, a green role in the townscape.
Yes.
Yeah, okay, thank you. And then you go on to say, at paragraph 5.9, this largely undeveloped western side of the A131 plays an important role by acting as a green framework that marks the transition from High Garrett to Bocking and Braintree providing not only a degree of physical separation, but ensuring that they are perceived visually as distinctive settlements.
Mm-hmm.
Now, the reference to the green framework is your judgment as opposed to anything which is based on any development plan document, landscape character appraisal, or, as we'll come on to see in a moment, a landscape capacity analysis.
No. Yes.
Okay. And insofar as marking a transition from High Garrett to Bocking and Braintree is concerned, the way in which the settlement boundary of High Garrett operates is that, in fact, no, let's have a look at the settlement boundary. I think the best place to find that is in, this is Brockhurst's proof. This is Brockhurst's proof.
Sorry, did you say a page number?
Yeah, sorry, page 12. So page 12 should have figure 2.1, which is an extract from the inset map for High Garrett. Yeah. Now, so far as there are six, if you go from the top of the page, the furthest north, and we can see the settlement boundary drawn in black, that's High Garrett, isn't it?
Yes.
And then the next block to the south, which is going down the A131, is that High Garrett? Is that Bocking?
Yes. Yeah. It's High Garrett.
High Garrett. Yeah. Okay. So it has, dare I say, a rather quirky settlement boundary, and it's in two parcels.
Three. Three, really.
Three.
Or it was, yeah.
Okay. Yeah. And then if we go down to the southwest, there's a settlement boundary there, which that denotes the Bocking / Church Street settlement boundary, doesn't it? Okay.
Yeah.
So when you are talking in your proof of evidence about marking the transition from High Garrett to Bocking and Braintree, given the nature of the settlement boundary identified for High Garrett, that the appeal site performs no role whatsoever, does it, in marking transition from High Garrett to Bocking and Braintree, because you'll go past the appeal site and you'll then still get to another part of High Garrett. You see the point?
Yes, I do, but it's not in itself. It's part of the wider townscape.
Right. So transition from High Garrett to Bocking and Braintree, that's not something you rely upon, but the part of the wider townscape point is. Is that fair?
Yes.
All right. And then the perception of Bocking, High Garrett, Bocking and Braintree being distinctive settlements. Now, granting planning permission for the appeal scheme will not prevent High Garrett, Bocking and Braintree being seen as distinctive settlements, will it? For the reasons we've just explored.
No, but not in its. It would partly erode the setting that is there existing, I think.
That will just help me with that. The setting of
High Garrett.
Okay. The setting of High Garrett is the issue. Right, fine. Good. I mean, so far as coalescence is concerned, the council has a green buffer policy in its emerging local plan part 2, doesn't it? And the parcel of land at the end of Church Street, which is the parcel of land taken out of the Gladman scheme off Church Street, that's part of a green buffer, isn't it?
Yes.
Yeah. But notwithstanding the fact that the council does have this policy tool and is anticipating a green buffer to separate High Garrett from Bocking, my client's site does not form part of any proposed green buffer, does it?
No.
No. Thank you. Landscape capacity study next, please. Forgive me, this is something I'd left off the list of documents that you would need. I apologise for that, but it's CD 8.13. CD 8.13.
Yeah.
Just wait for the inspector to. So do you have it?
I'm just getting it. Sorry,
Sorry.
Mr. Mac.
Thank you.
Yeah,
That's
I'm
right.
just getting there now, Mr. Easton. Yes, I've now got the documents open.
Thank you very much indeed. This, I think, as you accept in your written evidence, Mrs. Banks, is a relevant document.
Yes.
It was prepared by independent and reputable landscape experts.
Yes.
And as you tell us at paragraph 5.12 of your proof, that it is a document that is was commissioned by the council to provide an evidence base and to assist in the landscape evaluation of applications.
Yes.
So it has a plan making and a development management role, doesn't it?
Yes.
Okay. Now, just to take that point a little way forward, could we please, I'm going to come back to CD 8.13, but I'm afraid to ask you this question, what I do need to take you to is the emerging local plan part 2, which is CD 5.1.
Yeah.
And when you get to CD 5.1, if you're going by PDF page numbers, can we go to PDF page 133, please?
What's the actual page of the number of the document?
129, bottom of page 129,
that,
paragraph 825,
Mhm.
which says in 2015, the council commissioned capacity analysis studies for the fringes of Braintree, and there's a list of the places which did include, you'll confirm, won't you, that the area around the appeal site and High Garrett.
Yes.
Yeah. This provides a finer grain assessment of areas identified as low and low to medium capacity to accommodate development. This helps to determine which parts of these areas could absorb development with appropriate mitigation measures and minimal impact on the landscape. These analysis documents form part of the local plan evidence base. So far, so good. But then let's look at paragraph 826. Every landscape character area is important, although some may be more sensitive to change than others. Therefore, when considering development proposals, it will be necessary to consider the specific details contained in the landscape capacity analysis and the landscape character assessment for that particular landscape character area.
Yes.
Okay. So what your emerging policy is telling us, which I don't think is inconsistent with your written evidence, is that individual applications should be determined by reference to and having regard to the landscape capacity analysis and what it says about the individual development plot.
Yes.
Yeah, okay. Now, having said all that, can we just see what the landscape capacity analysis actually does say about the appeal site? And to do this, go back to core document 8.13. And there was quite a big mismatch between PDF numbers and page numbers. PDF number 30, page 37. And internal page 31.
Yep.
And there's a subheading parcel 13A, which you'll confirm
Yes.
is the within which the appeal site falls. 13A is both my client's site and the site to the south.
Yes.
Yeah. And can we agree, please, Mrs. Banks, that insofar as the landscape qualities and the role that those two different parcels play, there isn't, so far as this analysis is concerned, you don't draw any particular distinction between the two of them?
No.
No. All right. So this is the landscape partnerships analysis of parcel 13A, which you'll agree ought to be taken into account in determining the acceptability of this proposal.
Yes.
Yeah. Okay. Can we then look, please, to paragraph 436? Development within the parcel will form a natural extension to High Garrett, infilling the gap between existing residential areas to the south and the north. The change in topography to the west provides separation between the parcel that's connected to High Garrett and the sloping arable farmland that adjoins it. These factors in the existing landscape framework present good scope for provide landscape mitigation in the medium term. Now, a couple of points emerge out of that. First of all, in terms of its suitability for development in landscape terms, we have the expert landscape architects commissioned by the local planning authority offering the view that it would form a natural extension to High Garrett.
I don't think that was what they were really asked to do, were they? They were asked to assess the landscape.
That's exactly what they're doing in that paragraph, Mrs. Banks. And they're offering their professional judgment that the proposal would form, that the development of the entirety of that parcel would form a natural extension to High Garrett. So we have reputable independent landscape architects commissioned by the local planning authority who've produced a document which is relevant to decision making, forming a diametrically opposed view to the view that you're expressing to this inquiry. And that's a fair summary of the position, isn't it?
Pretty much, yeah. Yeah.
And then so far as any separation or coalescence is concerned, the second sentence confirms that the change in topography to the west. So you know, don't you, that if you're on the site, you're looking to the west, there is a substantial landscape belt on the western boundary.
Yes.
And then if you move further to the west, the land slopes away.
Yes.
Roughly towards Bocking. And what the landscape experts who produce the landscape capacity analysis say is that the change in topography provides separation. So there's a plateau which forms part of the appeal site, and then there's a sloping arable farmland that goes away. So no concern is expressed at all, is there, in the expert analysis about any coalescence or lack of separation?
No.
Again, a view that is expressly the opposite from the view you were expressing in your written evidence.
Well, it's given from a local. I think the council is most concerned, not so much of the views from within the site, but from the east, looking into the site and the function that that piece of land makes in collaboration with other, the rest of the land on that side of the road. We're not trying to say the experts are wrong, but we just don't agree that this proposal here is acceptable in this location. Yeah,
but you're not saying the experts are wrong. Okay, so the inspector will have noted that. Now, on that basis, is it not all the more important, Mrs. Banks, where you don't disagree with the expert analysis about the role that this piece of land plays in the wider landscape, to articulate in a convincing way why planning permission should not be granted in relation to landscape or visual impacts? It's more important, doesn't it?
Yes.
Yeah. And so far, I'm really sorry to say this, Mrs. Banks, that you have demonstrated that there is absolutely no evidence-based document or landscape character assessment which justifies the conclusions you've reached about the role that this piece of land plays in the townscape or as a separating function or any of it, have you?
Yeah, well, yes, up to a point, I would agree.
Right. Thank you. Now, so far as visual amenity is concerned, you haven't carried out any assessment of the sensitivity of visual receptors or the magnitude of change that would arise if development took place?
No.
No. And I think what you do though is you refer to one particular viewpoint. I'll just remind myself of so would you go back to your proof, please, page 24. And this is where you draw your conclusions in relation to landscape and visual impacts. The bottom page, having referred to a softer road to the busy highway and allowing views through into the countryside beyond the site and behind Grove Field. Now, so far as views are concerned, and so I'm not going to take much time on this because the inspector's walked the area, he'll have formed his own judgment already. But would you take up for just the briefest of moments, please, Mrs. Brockhurst photo montages?
Oh, hang on.
And
which page?
right, so it's page 6. So page 5, forgive me. So page 5 is a photo montage taken from viewpoint 6.
Yeah.
Okay, so if we're going on a walk, we'll have walked across the northern boundary of the site, and we're following the public rights of way out into the countryside to the west of the site. And again, look, this is a matter for the inspector's judgment, but I just want to draw to your attention that the extent of intervisibility between the appeal site and the wider countryside beyond is going to be extremely limited, isn't it?
I would agree.
Development. Yes.
But I would point out that these photos appear to be from within the site. The point that the council's trying to make is the viewpoint from the east side, because you actually do get glimpses of the countryside beyond, further down to the southern end of the site and behind Grove Field.
Right. So did I hear you correctly just then? You said that I'm asking you to look at viewpoint number. It was page 5.
It's not come up very well on here, I'm afraid.
Okay. Well,
Appendix 1, yes.
Yeah, appendix 1, viewpoint number 6. I might have misheard you when you, well, I thought you said that these photographs are taken from within the site.
Well, they seem to be taken looking across the site from the public footpath, I guess.
That's exactly right. So it's viewpoint number 6. If you can see the inset plan, we can see viewpoints 2, 6, and 7.
Yeah.
And viewpoint number 6 is on the public right of way to the northwest of the appeal site, and so we are looking roughly in a southeasterly direction towards the site when we are considering this particular photo montage, aren't we? So we're not within the site, we're outside it.
No, sorry, beg your pardon. Yes, I see now.
Okay.
Yeah. So I just interject there, Mrs. Banks, have you got a paper version of this document?
No.
You've not got access to one?
No.
Okay, well, continue, Mr. Easton. Okay.
Yeah, thank you, sir. All right. Well, that's all I'm going to ask you about in relation to those those photo montages. Thank you. The other thing I just wanted to, and so one of the things the photo does demonstrate is the planting that forms the western boundary of the appeal site.
Yeah.
Yeah. And one of the conditions that would be attached to the grant of planning permission would be a landscape management plan condition, wouldn't it?
Yes.
Yeah. And so to the extent that that needed to be strengthened and managed, that tree belt, that would be something that the council would have control over in discharging the management plan condition, wouldn't it?
Yes.
Yeah. And as matters currently stand, the council has no mechanism whereby it can ensure that that landscape belt is maintained or strengthened.
If the land is undeveloped, are you saying?
Yes.
Yes, that's right. We wouldn't have any control.
Thank you.
No.
And so to I think the strengthening and management of the landscape belt would be a positive thing, wouldn't it, Mrs. Banks?
It's arguable.
Yeah. And so so to that extent, the ability of the council to control the future maintenance and management of that landscaping belt is a benefit which weighs in favour of the proposal, isn't it?
I wouldn't. No, it doesn't overcome our fundamental objection to the development of that site, I don't believe.
Right. So we'll come on to. In fact, no. Let's go to it now. I think I've asked enough questions about landscape and character impact. The inspector understands our case, and I think understands yours. But the last answer just causes me to explore this point for a moment. When one is carrying out the planning balance, the exercise at its most basic requires a decision maker to consider all of the adverse impacts and then to weigh them against all of the benefits before reaching an overall judgment about whether the adverse impacts outweigh the benefits or vice versa. Okay, so in that exercise, and I'm using your view about the benefit of landscape management as an example, in that exercise, you wouldn't start off by saying, well, there may be a landscape benefit in terms of management and maintenance, but I'm going to reduce the weight to attach to that benefit because in and of itself, it doesn't outweigh the harms. That would not be the right way to do things, would it?
No.
No. You would say it's a benefit. I'm going to attribute a certain amount of weight. And then as part of my overall judgment, I would attach medium, moderate, significant, limited, whatever. But that all plays into the overall weight you'd attach to the benefits as a whole, wouldn't it?
Yes. Yeah.
Okay. Well, thank you. Now I'm going to ask you about the benefits now. We can agree, can't we, that in respect of housing, the delivery of housing, market housing, first of all, if, contrary to our case, the inspector concludes there is a 5-year supply, the existence of a 5-year housing land supply is not justification for refusing planning permission, is it?
No.
No. And the reason for that is twofold. First of all, the housing requirement in the local plan part 1 is a minimum figure, isn't it? Not a ceiling.
Yeah.
And second, we know from national policy that significantly boosting the delivery of housing is a fundamental and important objective of national policies, don't we?
Yes.
Yeah. And so even in circumstances where there is a 5-year supply, positive weight must be attached to the delivery of market housing.
Yes.
Yeah. Okay. Wouldn't it also be right to note, in the context of the government's objective to significantly boost the delivery of housing and the housing crisis, to give significant weight to that benefit?
No, we've given it we weighed it as less than significant because in terms of the wider housing supply need and the identified sites that we've got in our revised local plan, etc., don't mean it would make a significant contribution to that.
All right, well, we'll explore that in a moment, but can I just pick you up on a thing you just said, and not for the first time? You said we give it less than significant weight.
Mm-hmm.
Now, that may be just the way you express yourself, but you do appreciate, don't you, that what I'm trying to test and what the inspector is most interested in is your professional judgment.
Yes.
Okay.
Well, clearly, housing is an important benefit, but it has to be weighed against all the other factors.
Right. So can I just press you a little further on that? So your professional judgment is that the delivery of market housing is an important benefit.
Yes.
Can I tempt you to accept that it's a benefit of significant weight for the reasons we've just explored in your professional view? Not interested necessarily in what the council's view is corporately. I'm interested in what your professional judgment is as a very experienced planner.
My view that would be that I still don't think it would carry significant weight. I think it's an important benefit and it carries the weight that it's been attributed. But in the overall scheme of things, I don't think it could be a significant benefit.
Right. Can we also agree, please, in national policy, there is no requirement, there's no suggestion that residential development can only attract significant weight, for example, in relation to delivery of market housing, if it's somehow out of the ordinary or special. And perhaps it'll help if the reason I'm asking this question is that in your proof of evidence, at paragraph 721, you say, overall, while I note the above benefits in the planning balance, I consider these are all benefits which are common to any proposed residential scheme of this size.
Yeah.
That's the reason I asked that question.
Mm-hmm.
But there is no requirement, is there, for a developer to be able to demonstrate that their scheme is somehow out of the ordinary or special or meeting a very particular need before significant weight could be attached to any of the benefits?
No.
And I think that must be right, so I'm glad that you've said that. Can we go back to the NPPF, please? And when you have it, can we go to paragraph 81?
Yeah.
I'm asking you questions about the economic benefits because one of the benefits that we pronate is the introduction of an economically active population and the benefits associated with constructing the scheme. And the second sentence of paragraph 81 says significant weight should be placed on the need to support economic growth and productivity, taking into account both local business needs and the wider opportunities for development. That isn't qualified, is it, by reference to the ordinariness of the scheme or indeed the size of the scheme in question?
No, but it's not specifically talking about housing, is it?
Well, it's talking about all development, Mrs. Banks.
Okay.
Isn't it? Need to support economic growth. It would be odd, wouldn't it, if national policy suggested that you could give significant weight to economic growth with huge distribution warehouses for Amazon, whereas the economic benefits that you would obtain from putting people in the local area and in construction jobs was left out of account.
Yes, but they are fairly short-term benefits, aren't they? They're not benefits in the longer term.
Yeah.
Whereas,
okay. So I didn't want to cut you off if you wanted to say something else.
That's fine.
And then the other thing I just would like to draw your attention to, please, so far as, and this is the size point, and I think the size of the scheme. So I think, do I understand you correctly that if my client was proposing 1,000 houses, that would get commensurately more weight in the planning balance because it's 1,000 houses, not 37.
Mm-hmm.
Yeah.
Yes.
Okay. Can we go to paragraph 69, please, of the framework?
Yeah.
Small and medium-sized sites can make an important contribution to meeting the housing requirement of an area and offering built out relatively quickly. So what the government's telling us there, partly for the reason that it's pretty obvious you can build out a 37-unit scheme pretty quickly,
Mm-hmm.
is that smaller sites have an important role to play in significantly boosting the supply of housing. That's what that policy says, isn't it?
It says they can make, yes, it does.
Yeah. And so in that sense, when you say things like benefits which are common to any proposed residential scheme of this size, that comment's made in ignorance of the government's support for small and medium-sized sites as an important contributor to housing demand supply, isn't it?
No, it's not saying that we should then grant every single small scheme that comes along because it would make a small contribution to housing supply or whatever. You know, we recognise that, but it doesn't mean to say that then is an automatic grant of planning permission.
No, see, I thought you might start saying this sort of thing, Mrs. Banks, which is why at the beginning of the benefits section, I was very careful to say, and I thought you agreed, the way in which you carry out is you consider each of the individual benefits before taking all of the benefits into account and reaching a judgment and comparing that to the adverse impacts. I'm not suggesting that in each and every case where one is promoting 37 houses, because small and medium-sized sites can make an important contribution to meeting housing requirements,
I'm not saying that you are.
Automatically get planning permission. What I'm trying to explore with you is what I would suggest to be the proper and correct approach to calibrating the weight to individual components on each side of the balance. Okay, all right. So far as affordable housing is concerned, would you take up anything you say well, you don't make a distinction, do you, between market and affordable housing? Now, affordable housing is a strange material consideration in the sense that there's a policy requirement to deliver affordable housing.
Yes.
And the emerging policy requirement, I think, is 30%, isn't it? So if the local plan part 2 were adopted, it would be a 30% requirement.
Yes.
Yeah. Whereas my client is proposing 40%.
Yes.
In excess of the emerging policy requirement. Okay. So that must attract some positive weight, mustn't it?
Yes.
Yeah. And affordable housing also is a requirement that has nothing to do with the impact of the scheme in question, because affordable housing pre-exists the grant of planning permission.
Yes.
Yeah. And so the other thing I'd just like to explore, so obviously delivering market housing is meeting a need for market housing and meeting the government's objective to boost the supply of housing. But oughtn't we to treat affordable housing slightly different, in the sense that somebody who is entitled to affordable housing is in genuine housing need?
Yes.
Yeah. And that's why I think you'll agree with this, that affordable housing and market housing ought to be treated in a different way from each other, given the different context for market and affordable housing.
No, I don't think they should be. It's housing need, isn't it? That we're trying to Mm.
Yeah, but there's a qualitative difference, isn't there, between a young couple with a newborn baby who are in wholly unsuitable accommodation on the council's housing waiting list, and somebody else who is, a similar couple who are in broadly suitable accommodation but would like to upsize in due course, but aren't in overcrowded, unacceptable accommodation. Can you see there's a qualitative difference between the two? All right. Can we just explore the numbers in relation to affordable housing, but bearing in mind all the time that behind the numbers are people who are on genuine housing need. Mr. Murray Cox's proof, please.
Yeah.
And so to assist with timing, we're probably in the last 10 minutes.
Okay, thank you.
Page 27.
Don't do this. Okay.
Right, so that's Mr. Murray Cox's section on affordable housing, and then at paragraph 4.45 and the table below, what Mr. Murray Cox sets out is the annual requirement from the base date of the planned period of 212 affordable dwellings, and in the last column there is the shortfall or surplus. Now, you don't challenge the figure that there was a cumulative shortfall of 587 dwellings, affordable dwellings across the planned period. No. That's 587 households in genuine affordable housing need whose needs have not been met since 2013.
Yeah.
Yeah. And at 446, what Mr. Murray Cox says, there's therefore been a significant shortfall in affordable housing delivery in the planned period to date. That's a fair description, isn't it?
Yes.
Yeah. And then 447, Braintree District Council's response to an FOI request revealed that there's been no affordable housing completions in High Garrett between 2000 and 2001 to 2021. Since the turn of the century, there has been no affordable housing delivered at High Garrett. You don't challenge that.
No, because yeah.
Right. And then similarly, the FOI request also revealed that there were 2,464 households on Braintree's District Council's housing register as at the 1st of April 2021. Again, you don't challenge that figure either.
No.
Right. That paints a picture both across the district and at High Garrett of a substantial affordable housing shortfall to which the appeal scheme can make an important contribution, doesn't it?
It would make a small contribution, yes.
Right. You're back to the numbers point again. So
well, it would make it, yeah, I accept your point that it would make a contribution. Yeah.
Now, if you're diminishing the weight to attach to that contribution, I think by virtue of the fact that this isn't a 1,000-house scheme, to use the example I gave a few moments ago. But if you were to repeat that view across all sites of, say, 30 or 40 dwellings, but you would never take into account the amount of benefits to affordable housing delivery that cumulatively those sites would bring forward, would you? Because you'd say in every case, it's only a small amount, I'm not going to give much weight to it.
No, we would give, judging each case on its merits, we would give the weight that it's due as part of the supply of housing.
But in circumstances where there is an obvious shortfall, where there are nearly 2,500 people on the housing waiting list, I find it quite surprising that the council would give anything other than significant weight to schemes that would assist in meeting that substantial need.
I don't think I can answer your question.
Right. It is surprising, isn't it, that that's the position that you're taking on behalf of the council. And again, your professional judgment, please, Mrs. Banks. In light of the points I've just put to you, we should give significant weight to affordable housing delivery, shouldn't we?
We perhaps we should, I don't know, but we don't. We give weight to the amount of housing that would be supplied as a whole. Obviously, the amount of affordable housing is taken into consideration within the judgment.
Okay. Thank you. There's a number of other benefits which.
Sorry, Mr. Easton, could I just jump in there slightly? Yes, I'll do it now. Just a matter of clarification. I'm quite clear to him, Mrs. Banks, what weight you would give to the affordable housing contribution. Obviously, I've read your proof, but in terms of on a sliding scale, what weight would you give affordable housing?
Well, we would give it a lot of weight, yes, but it's relative to everything else.
But on a sliding scale, you know, one end, if you say,
we would
limited up to very substantial, where would you put affordable housing on that sliding scale?
It will be probably moderate to significant.
Okay, thank you.
So that's helpful. So you've got a lot. No, that's fine. You got there a lot quicker than I did. But so thank you. Would we go? So the few other points I just want to raise with you in relation to benefits. Your proof, please, Mrs. Banks. Page 30.
Yep.
Paragraph 720, you say, while the draft 106 has been agreed, the obligations, including the aforementioned affordable housing, open space, education and RAMS contribution on mitigation for the likely impacts of the development and are required in accordance to the policy. I therefore afford neutral weight to these benefits. Now, we've dealt with affordable housing. So far as open space is concerned, just as a concept, the financial contribution towards open space would be to the benefit of future residents of the appeal scheme, but would also be to the benefit of existing residents in the area, wouldn't it?
Potentially, but
yeah,
those sorts of benefits are required to offset the harm, for want of a better word, that new development would cause, because all development has an impact. Sorry, perhaps impact is a better word.
Right. Perhaps let's use the upgraded bus stops as an example. We've explored that already. Now, the upgraded bus stops would be to the benefit of both future and existing residents, wouldn't they?
But again, there are existing bus stops there, and it's just required that they are improved, and that is as a result of the scheme that's proposed. Yeah.
Now, I think we'd agreed earlier on that and the crossing would be benefits. Now, you must be able to conceive of a situation where contributions, financial or otherwise, secured through a Section 106 obligation to mitigate the impact of development, also had collateral benefits for existing residents of the existing area.
Potentially.
Yeah. And so obviously one has to reach a judgment about the weight you would attach to those collateral benefits, but you don't leave them out of account altogether, do you?
No, but usually the way we've looked at this is that if the scheme wasn't going to go ahead, we wouldn't need to ask for these benefits. These benefits or these contributions, or whatever you want to call them, are required to offset the impact of the development.
Yeah, but if the scheme is going to go ahead, not only will the potential adverse impacts be mitigated to an acceptable degree, there would also be those collateral benefits that I've been discussing with you, which you've completely left out of account, haven't you?
Mm-hmm.
Yeah, okay. The other benefit that you've left out of account is the provision of electric vehicle charging infrastructure. Not something that factors in your benefits, is it?
No.
No. Okay. And so, on the basis you've left a number of the benefits that I've put to you out of account in your overall planning balance, your overall balance is flawed, isn't it? It must follow.
I don't think so. I think the things that you're mentioning are sort of gilding the lily, as it were. That they're seen as trying to make the development more attractive, but what benefit is there to the wider public interest that you would provide electric car parking points in the proposed dwellings?
Well, reducing carbon emissions, sorry, I don't want to carry on if you want to.
Yeah, no, that's fine.
Question. Right.
No, that's fine.
Yeah, might I suggest that they're pretty obvious, and that is to encourage and facilitate sustainable modes of transport, which is a key national policy imperative.
Yes.
Yeah. Okay. So, and similarly, making the development more attractive or gilding the lily, as you describe it, doesn't mean, does it, that you leave those benefits out of account in your overall planning balance?
No.
No, because you could conceive of a situation where you had a series of benefits, each of which individually might only attract limited weight, but cumulatively might be sufficient to outweigh the harms. That's a logical possibility, isn't it?
There is potential, but I don't see that there is anything proposed here that would do that.
Okay. Mrs. Banks, those are all the questions. You can breathe a sigh of relief now, because those are all the questions that I have for you. Thank you very much for your cooperation.
Thank you.
Thank you, Mr. Easton. If there are any interested parties present who are in support of the proposal, do they wish to ask Mrs. Banks any questions? I'll take that as a no.
But we are moving down the list, so there aren't any. Just whilst I've got the floor, as it were, I know Mr. Williams quite well, and he's exceptionally careful, but I know he will be extremely careful in light of some of the concessions that were made during cross-examination when he's posing his re-examination questions. Okay, thank you. Mrs. Banks, I just have one question for you from myself, and it's really a matter of clarification, so nothing to worry yourself with. If you can turn to page 29 of your proof, and it's similarly, I think it's updating your proof from what was said yesterday by your colleague Alex Evans during the housing land supply roundtable session. At the top of that, obviously you refer to the council's position of 5.31. Obviously you heard what Mr. Evans said yesterday, and you would have read what was in the supplementary statement of the Station Road appeal update, which came in at the end of last week. So would you want to, what's your position in terms of the figure which should be in your proof? Do you want to put you're on mute?
I would be guided by what Mr. Alex Evans said yesterday.
Okay.
Which I can't remember off the top of my head, I'm afraid. But yes, obviously. I
believe it was 5.27.
5.27.
Yeah. I'm sure Mr. Williams can confirm that.
I can confirm that's the council's case.
Yeah,
so that the 5.27 obviously reflects the deduction of 50 from Broad Road, which was something the council arrived at after Ms. Banks's road proof. I'm sorry, I didn't clarify that in tune.
No, that's fine. Thank you. Mr. Williams, do you wish to re-examine your witness?
Yes, so I think I've just got 3 or 4, maybe 4 topics, please, Ms. Banks. First of all, could we take up paragraph 3.19 of your proof? And you're here dealing with the weight to be given to policies RLP2 and CS5, and you explain there a number of reasons why you consider the greater weight should be given to RLP2 and CS5 than the inspector and the Gilder Terrace decision did. He gave limited weight. Anything that you've heard or been read or put to you today changed your views that you set out in that paragraph?
No.
Next point. In relation to your proof, please, at paragraph 5.18. Sorry, I'm just looking at my notes. 1 second. Yes. Proof at proof at 7.5, page 27.
Yeah.
You tell us there that in your view, amongst other things, merging policy LPP1 is compliant with the NPPF.
Yes.
You say the same thing if we look at 7.3 about CS5.
Yes.
So I want to concentrate on LPP1 at the moment, please. If we take up, please, you were cross-examined on this, LPP1, which is CD 5.1.
Mm-hmm.
Go to page 33. About where the policy LPP1 is, do you see that?
Yeah.
And do you see it at 518 above? Sorry, 515 above.
At 514, do you mean?
515.
Sorry, yeah.
Referencing the NPPF, and it was the 2012 version of the NPPF.
Yeah.
That the council's view in promoting that policy, as it was consistent with the NPPF, particularly that paragraph set out there.
Yes.
Now, the wording in the main modifications approved by the examining inspectors has sought to be changed at the council's request from strictly controlled to confined.
Yes.
In your view, is there, in principle, any reason why settlement boundary policies, and in particular this particular policy, LPP1, is in conflict with national policy?
No.
Now, your considered view, please, because it was put to you, I think, that the strictly controlled does not is not consistent with national policy. Your considered view, please, as to whether, if a plan is meeting its needs in full, a development plan policy which sets settlement boundaries in the way this does is in conflict with the NPPF?
No.
Thank you. Next topic, you were asked about the IHT document, and could we pick that up, please? 8.7. And we need to go to page 12 of the PDF, table 3.2.
Yes.
And it was put to you that you'd misinterpreted this table. Can I have your help with this? Table 3.2, the title is Suggest the Acceptable Walking Distance. You see that? Singular.
Yeah.
And then it gives us 3 levels of different distance for 3 different types of facility.
Yes.
help me with this. In relation to town centres, what does it identify as the acceptable distance?
400.
So if a facility was a town centre use and it was above 400, let's say it was at 600, would that be within or outside the acceptable walking distance as you interpret this table?
Well, it would be outside.
Next topic, landscape and visual. Your para 517, please.
Yeah.
You summarise your conclusions there on the landscape and visual harm that would occur as a result of this development.
Yes.
Are those your judgments, your professional judgments as to the harm that would arise? And do they
Yes.
continue? Okay, this next question. Is there anything you've read or heard through cross-examination that's caused you to change those judgments?
No.
Now, you were criticised for not having an evidence base for them. I can make submissions in relation to the nature of such judgments, but if we look back at 512 in your proof and 513, you deal with the capacity study there.
Yes.
And we've seen the capacity study concludes this is has a medium capacity.
Yes, yes, yes.
Your help, please, with does a proposition that a site has medium capacity for development mean that if development occurs, there'll be no harm in landscape or visual terms?
No, it doesn't.
And just help me with this, please. We can take it up if you want. If you don't know, we'll go to the document. But did the committee report, sorry, the officers' report, did that engage with the capacity assessment? Did it acknowledge its existence?
Yes, it did. It was very thorough in its analysis of what the landscape capacity assessment states or says.
And what did, and we know that you weren't responsible for that, but what was the professional view of the officer who drafted that document as to whether there was or was not landscape and visual harm?
She concluded that there was visual harm, landscape and visual harm.
And then just help me with this, if I may. You explained both in evidence and chief, you've done it in your proof and in response to cross-examination, that in your view, the development of the appeal site would erode the setting of High Garrett.
Yes.
And in your view, does High Garrett have the same or materially the same character or a different character to that of Bocking and Braintree?
It's different. Its character is a little bit odd. It's partly expressed by the way it's developed over the years, but it has an urban edge to it, and then there's the countryside on the other side of the road. Whereas if you were in Bocking or Braintree, it'd be more of a developed and urban field than you get in High Garrett.
Thank you. And what would happen if this appeal site develops to the difference in character that currently exists between High Garrett and Bocking or Braintree?
Well, it would erode that sort of green edge and that sort of sense that you've got of 1 minute being in an urbanish area and the countryside. I mean, that boundary sort of provides a mark as to where development ends and countryside begins.
Thank you. Those are my questions in re-examination, so thank you very much.
Thank you, Mr. Williams. I am now going to adjourn for lunch, but I just want firstly to talk first in relation to Mr. Grist's evidence. Obviously, as I said yesterday, I'm obviously very keen to get through Mr. Grist's evidence this afternoon. So that may mean Obviously, the session may be slightly longer, or indeed, depending on how we get on, I may split the session into two, depending on how we go. But I would obviously, I'm not, my usual practice would give an hour for lunch. But if I said we'd resume at 1:45, so that'll be 45 minutes. Mr. Easton, would that present you with any issues?
Not at all, sir. Thank you.
No. And Mr. Williams?
No, sir, I think it's a very good suggestion.
Okay. Mr. Easton, anything further to raise before I adjourn?
No, thank you, sir.
Mr. Williams?
No, sir.
Okay, thank you. So the time is now 1 o'clock, so I'll adjourn the inquiry and we'll resume in 45 minutes at 1:45. Thank you.
Thank you.
The time is now 1:45, and it's time for me to resume this inquiry. Mr. Easton, would you now please call your first witness?
I will, sir. So I'm going to call Matthew Grist, who I can see is on my screen. It should be on everyone else's. So I don't propose to be terribly long, and I think it's unlikely that we'll need to refer to many documents other than Mr. Grist's proof and appendices. But where we depart, I'll give you due notice, and we can get the documents in front of us. So I'll introduce Mr. Grist to the inquiry through page 5, section 3 of his proof of evidence. You're Matthew Philip Grist, you're Director and Head of Transport Planning at JUB, who are a multidisciplinary consultancy. You set out your various academic and professional qualifications, which include the fact you're a member of the Chartered Institute of Logistics and Transport and the Chartered Institution of Highways and Transportation. You have considerable experience in the field of transportation, over 30 years, both in the private and public sector. Are those details all correct, Mr. Grist?
Yes, they're all correct.
Thank you very much. And then at 3.1.3, you tell us that you provided transport and highways advice regarding the appeal scheme since 2019, visited the site on a number of occasions, including during peak periods, and you're familiar with the local surroundings and conditions. Is that also correct?
That's all correct, yes.
Thank you. And then 3.1.4, you set out your expert declaration. Does that hold good today?
It does, yes.
Thank you very much indeed. We'll take your written evidence as read, Mr. Grist, but there are a couple of points of clarification and perhaps elucidation I'd like you to help the inquiry with as we go through. The first one of which is so the nature of the highway network, and particularly the A131, having regard, if you can have in your mind, Mrs. Banks's evidence about the speed of traffic, the busyness of the road and such like.
Yes, I mean, the A131 is an arterial road into Braintree. As I sort of said, they're in category A road, 40 miles an hour, and the level of traffic and the speed of traffic is what you'd expect for that category of road leading into a town. So, I don't see it as something unusual with regard to category A roads leading into towns.
Okay, thank you very much. Next, please, can you go forward in your proof? This is a couple of policy questions. Page 11 of your proof of evidence.
Yes.
Paragraph 5.1.3. You indicate that the NPPF doesn't require or that all residents of a development undertake their trips by sustainable modes of transport, and you make reference to offering a genuine choice of transport modes. But can I just have your view on this, please? Mrs. Banks, in evidence in chief, made reference to paragraph 105, with particular focus on the reference to significant development should be focused on locations which are or can be made sustainable. And that was in response to something we may come on in due course to consider, which is the council's approach to other residential developments in High Garrett, albeit of a smaller size.
Yes, I mean, paragraph 105 talks about significant developments, but I think, as was discussed this morning as well, paragraph 110 also requires that developments take up appropriate opportunities to promote sustainable transport modes, given the type of development and its location. So the sort of thrust of that policy doesn't just deal with significant development, as you might call it. It sort of passes on through to developments as a whole. Really, they need to be considered with regard to sustainable transport.
Yeah, and in relation to paragraph 110A, Mrs. Banks accepted that would apply to any development irrespective of its size. Do you agree?
Yes, that's correct. It's something that needs to be looked at on all developments. Yeah.
Thank you. And then go back to your proof, please. At 515, you draw our attention to the MPPF definition of sustainable transport. Again, we went through this with Mrs. Banks, but is there any particular reason why you want to draw our attention to that particular definition?
Yes, I think it's relevant to this development in as much as the modes that are mentioned there and methodologies in terms of reducing the need to travel and encouraging sustainable transport. This development certainly does all it can to embrace them. It's got a condition to require all dwellings to have electric vehicle charging points. It's also got a travel plan is secured by condition that will encourage car sharing. And my evidence also looks at the public transport element, which certainly I think was agreed this morning that there's a good level of public transport provision there right outside of the frontage of the site. And with regard to walking, there are walking links to the frontage of the site. No doubt we'll talk about them in more detail. And with regard to cycling, there are opportunities for certain cyclists to use the A131, people who are probably more confident cyclists. There's also the opportunity for people to work from home as well. So that there's a whole sort of package of sustainable transport options that this development offers up.
Okay, so, but just in that respect, it is an assessment of whether a site is sustainable in transport terms, a tick box exercise. And by that I mean, is it walkable? Can you cycle? Do you have to deliver in every single aspect of sustainable development, walking, cycling, public transport, zero emission vehicles, car sharing? Do you have to deliver in all those aspects in order to reach a judgment that a site is sustainably located?
I don't think so, no. I think it's offering a genuine choice, which is going back to paragraph 105 again. It's about that genuine choice of sustainable travel options. Doesn't mean you necessarily have to offer all of them, but it's a case of a development offering a genuine choice for the residents who are going to live there.
Okay, just take that step further. Let's assume that it was necessary to offer all of those options as sustainable alternatives. Would the appeal scheme meet that objective?
I believe it would, yes.
Yeah. So far as car sharing is concerned, you did refer to the travel plan, and that could encourage car sharing. But would that be all that the travel plan would do?
Not necessarily, no. I mean, the travel plan can incorporate a whole package of measures, car sharing being one of them, buddy systems for walking, cycle user groups, potentially vouchers for use on buses and other methods of public transport such as rail. Travel plans can incorporate a whole range of measures. So car sharing is one aspect of that, but wouldn't cover the whole. I wouldn't expect that to be the only thing within the travel plan.
Okay, thank you. Next, please. The county council's attitude towards this proposed development. We can actually deal with this relatively briefly, I think, in light of Mrs. Banks's evidence. But go back in your proof, please, to page 7.
Yes.
On the top of page 7, you make reference to the county council's consultation response, where they say from a highway transportation perspective, the impact of the proposal is acceptable to the highway authority. And I have two questions, really. The first one of which is, did the county council, in your judgment, consider the sustainability of the location and its accessibility? And secondly, what weight would you attach to the county council's views?
I think they clearly did consider it, yes. They refer to their development management policies, in particular DM9, that deals with transport sustainability. And they also state quite clearly with regard to the site to the south the other appeal site, that they've considered sustainable transport modes and the ability, as far as possible, for residents to travel to that site by the sustainable modes. So I'd be extremely surprised if they didn't. In fact, it says that they have, and I think it would be highly unusual for a sort of highway transport development control officer not to consider that. In my experience, I can't believe Essex is any different, but authorities look at all issues, not just highway capacity and physical infrastructure. They look at the accessibility of a site. But in this instance, I think we've got the evidence there to show that they did consider sustainable transport, and that should be given significant weight, because the transport planning experts at Essex County Council have looked at this site and deemed it to be acceptable in that regard.
Okay, thank you. Now, we've touched on a few of the modes of travel that people could use as an alternative to the combustion engine private car, but I'm just going to run through now what travel options residents have to travel to and from the site. I think you've mentioned working from home, you've mentioned electric cars, you've mentioned car sharing. Buses, I suppose there are two aspects to this. First of all, the quantitative aspect, the frequency of service, proximity to the bus stop, and secondly, qualitative, which really was Mrs. Banks' only focus, crossing the road to the southbound bus stop. So can you deal with them in that order, please?
Yes, so in terms of the services themselves, and I think they can be categorised as good services. I set out in my proof the number of services that exist there, and the frequency, approximately three buses per hour heading towards Braintree. Some of them go via Bocking and some don't, but in total 3 buses per hour in general. Bus journey times of 3 to 4 minutes to Bocking and 9 minutes to Braintree. And they're right outside of the frontage of the site, so within 150 metres of the centre of the site. I think that constitutes a good level of public transport provision, and I'd say probably better than in some urban areas. I deal with sites all across the country, and when you look at some parts of cities, that they have nowhere near that level of provision. So in terms of the quantitative element, I think it's a good level of service. In terms of the stops themselves and the ability of residents to get to them, clearly there's a condition requiring improvements to those stops and crossing facilities to get to them, as required by Essex County Council. And then it comes down to the point of whether it's safe for people to, or I don't think it's even the safety point now, it's more about whether people will be put off from crossing the A131 to get to the southbound stop. And I just don't consider that to be the case based on my site visits, the fact that Essex County Council officers have reviewed the situation and deemed the crossing to be acceptable, and the fact that there are other crossings on the A131 in High Garrett of a similar nature that have been implemented by the County Council. So I talk in my proof about the platoons of traffic on the A131 and the ability of people to make a value judgment based on their sort of ability to walk around the pedestrian network. I think it's untrue to suggest that pedestrians aren't able to make a safe and valued judgment about when to cross a road. They can judge a gap and cross accordingly, and I believe there are adequate gaps in the traffic in this location to enable that.
Okay, couple of follow-up points. First of all, if Essex County Council considered that a crossing or was unsafe or was a significant disincentive to people, there would still be a significant disincentive to people crossing the road, how likely do you think it would be that they provided the bus stops and the drop curbs to 300 metres south of the Hare and Hounds, or would have recommended a condition that the appellant is prepared to sign up to?
That they would have required it. It would have, that they clearly looked at this application in detail and came back during the life of the application requiring some amendments to the footways and the crossings. And if they'd felt that another form of crossing was necessary, I have no doubt they would have requested it. But they didn't, based on their assessment, analysis of the situation.
Okay. The second follow-up question is this. Presumably as part of the transport assessment supporting the planning application, an analysis of personal injury accidents, both vehicular and pedestrian and also cyclists, was carried out, was it?
It was, yes.
Yeah. Is there any evidence whatsoever of any personal injury accidents relating to people crossing the A131 in the vicinity of the appeal site?
No, there were no pedestrian accidents on the A131.
Okay, well, whilst we're on the topic, anything related to cyclists?
No cyclists, no.
No. Thank you. So that's anything else you want to say about buses, Mr. Grist?
I don't think so, no. I think I've said it all. I've set out that I believe it's a good level of bus service. And that's my conclusion on the matter.
Okay, actually, before we leave it, I just would like you give you an opportunity to comment on Mrs. Banks's evidence, which is to the following effect, that it was unlikely in her view that people would get on the bus because it would be so much more convenient to get in the car. Now, as a general proposition, how reflective or otherwise is that of national policy?
I think it's I don't agree with that proposition. I think bus is an important part of the transport or sustainable transport mix that's required throughout the country and delivered throughout the country, and bus services offer great opportunities for people to travel, and there's all sorts of reasons why people use the bus. It may be on a cost basis, it may be that the destination at the far end, maybe they work in Braintree, they don't have any parking outside of their office or wherever they work, so there's all sorts of reasons why people would use the bus. They may use it for leisure, to go to leisure facilities. It's an important part of the mix, so to just dismiss it as a mode that people wouldn't use, I think just isn't a true reflection of what happens in reality. Bus is an important mode of transport, and the government are certainly behind it in terms of growing bus percentage with their bus back better strategy. So I think you can't just ignore bus and just say that everybody will drive the car, because that isn't the situation.
Okay, thank you. Cycling, I think you acknowledge, don't you, that travelling to services and facilities in the local area is likely to be an alternative only for confident cyclists. Is that your position?
Yes, that was my position, yes.
Yeah. And Mrs. Banks makes reference to, I think about 2% of people from the Bocking North Ward travel to work by bike. I mean, just 2 points. Firstly, is that low, high, average? And the second point is that even if only 2%, even if the travel patterns from the appeal site reflected that 2% average, does it mean that we should set aside cycling as a choice of sustainable transport modes?
No, I think the point I was making when I was saying confident cyclists was that I wouldn't expect somebody to sort of try and learn to ride a bicycle or maybe cycle with their young children on the A131. I wouldn't expect that. I think that would be unreasonable. But for a confident cyclist, of which there are many, cycling is quite an important and sort of growing mode. It's still a small percentage. The 2% in the Bocking ward is representative of nationwide. Actually, that's nationally, the mode share of cycling is only about just around 2%. So Bocking is nothing unusual in that regard. But I think there would be potential for cyclists, the confident ones, perhaps the sort of more hardcore commuter type ones that we see around on the road network, would certainly cycle along the A131. That was the point I was making. It wasn't to dismiss it as a whole, but to be realistic that it would purely be cyclists that are confident and used to cycling on roads such as the A131.
So even if it were 2% of the people who lived in the appeal scheme would travel to work by bike, as a choice of a sustainable transport mode, is that something that ought to be factored into the sustainable travel mix?
It is, yeah, it's an element to be factored in, yes. And I think the travel plan would probably have measures within it. It would obviously have to be agreed with Essex County Council, but often it's seen that people are potentially offered vouchers for cycle equipment and what have you to try and encourage cycling. So it's part of the mix, and at 2%, it's not a massive proportion of travel nationally, but it's something that should be encouraged and not dismissed.
Okay, thank you. Walking. Now, there are a variety of pieces of guidance, PPG 13, the IHT guidance, Manual for Streets, National Travel Survey, which give indications about the distances people are prepared to walk to service and to facilities. I'd just like you to draw things together, please, but perhaps the best jumping off point, as it were, was your section 5.3, page 12 of your proof, pedestrian accessibility.
Yes, sure. I mean, I guess it comes back to the refusal reason, which says that amenities are beyond a reasonable, and I think we've.
Mr. Grist, you've gone on to mute.
Apologies, I hit my keyboard there. My mistake. Yeah, sorry. I don't know where you heard me to, but as I was saying, it was really about the refusal reason, and the wording is beyond a reasonable walking distance. So what I was trying to do in that section 5.3 was to try and basically look at guidance. And as I pointed out there's the IHT guidance, there's Manual for Streets, there's the historical PPG 13 guidance. There's also some guidance that Mrs. Banks mentioned in her proof, the WYG review of walking distances as well. And then I've taken that, which in my view gives a figure of around 2 kilometres as a reasonable walking distance. And what I've then gone on to do is look at National Travel Survey data to see if that sort of corroborates with that 2 kilometre distance. And so I've put in 3 pieces of National Travel Survey data there. Under my appendix MPG 3 is a table that shows that just under 1/3 of journeys between 1 and 2 miles are undertaken on foot. So, i.e., 1/3 of all journeys between 1 and 2 miles are actually undertaken by foot. So that would suggest that that's 1,600 meters to 3,200 meters. So that would again suggest that the 2 kilometers is a reasonable distance, and a distance that people do in fact walk to regularly. The next piece of evidence,
pause there for a second, Mr. Christie, if you don't mind, just to set that some sort of context. So let's say, but based on your experience, so let's say the people who lived on the appeal site were reflective of the results of the National Travel Survey, and 1/3 of them conducted journeys of between 1 and 2 miles on foot, how, I mean, well, first of all, how likely is that? And secondly, if that were to happen, is that good, bad, indifferent in terms of a modal split?
I think, yeah, I mean, the area that we're looking at in Bocking, the key facilities we're discussing there are between 1 and 2 miles, and this table looks at that particular distance and confirms that approximately a third of all journeys taken between 1 and 2 miles are by foot. So that would suggest that people do already nationally walk between 1 and 2 miles, and would suggest therefore that the facilities that we're discussing, particularly the primary school and the co-op, are within the sort of distance that people would be willing to walk to. But that was my point with that. The National Travel Survey is, as it suggests, a survey of travel nationally. It's undertaken annually by, I think there's about 7,000 households that it covers, and it's actually a sort of a survey of people's travel habits across a week, and it includes all members of the household, so it encapsulates children as well as adults. So I think it's quite a useful tool in sort of trying to determine whether these distances are sensible or not, and it's also used by government to set policy. The data coming from it is used to set government policy. So that was the point I was trying to make with the 1 to 2 mile section under my MPG appendix, MPG3 appendix.
Okay, thank you. So I interrupted you, and you were going to go on to explain the other sources of guidance and statistical evidence.
Yeah, so the next table is under my appendix MPG4, and that shows that the average walking trip over 1 mile is 31 minutes long. So for again, this is the sort of area that we're talking about in Bocking, it's over 1 mile, and the actual average walking time is 31 minutes for journeys over 1 mile for walking. So that would again suggest that people are willing to walk to the primary school and convenience store, because based on 1.4 meters per second walk time, they would be approximately 23 and 26 minutes walk. So if the average walk time is 31 minutes, then people would generally be willing to walk those distances. It's again my analysis of why this sort of 2 kilometre or thereabouts distance is a reasonable level to be set.
Okay.
The final one, my appendix MPG5, regards children walking to school, and that shows that 46% of trips to and from school for 5 to 10-year-olds are undertaken by walking. So again, that would suggest that it is feasible and it does happen quite regularly. 46% of trips are by foot for 5 to 10-year-olds, and that the average trip length is actually 1.8 miles, and that equates to 2.8 kilometres. So again, the primary school is well within that. So I'm not saying everybody's gonna walk to the school, but this data would suggest that a large proportion of people do and would from this development. So in the round, that data combined with the guidance, I believe, provides a reasonable conclusion that approximately 2 kilometres should be considered as a reasonable walking distance from the site. And people
Okay, thank you.
Beyond 2 kilometres.
Yeah. All right, I'll come back to your overall conclusion in a moment. One thing I just would like your help with, because it's probably a document you've looked at quite a few times, is the IHT guidance, which is core document 8.7.
Yes.
It's page 12 of 25 of the PDF, but it's table 3.2, which has the heading suggested acceptable walking distances, and they have desirable, acceptable and preferred maximum. I'm not going to spend an awful lot of time on this because we went through it in cross-examination with Mrs. Banks, but how do you say one is to read that table?
I think it's in the title. It's a range of acceptable walking distances, and the preferred maximum acceptable walking distance to school is set out in there as 2 kilometres. So I think, yeah, it's could be read as being a bit confusing because acceptable is in the table and acceptable is in the title, but the fact the title says acceptable to me means that it's a set of acceptable walking distances. And I think that's, the reason why I've looked at that other guidance and this national statistical analysis to try and prove that 2 kilometres is actually a reasonable walk distance. So it means that table in isolation isn't, if you like, the sort of be all and end all in this regard.
Okay, thank you. And then just whilst we're on the table, please, that there's the first column of destinations is town centres. Now, in the circumstances of this case, so the preferred maximum acceptable distance to town centres is 800 metres. The co-op is just over 2 kilometres from the appeal site. Ought we to be judging the distance to the co-op by reference to the preferred maximum of 800 metres? Would that be an appropriate reading of that table?
No, I don't think so. I don't think Bocking is a town centre. It's a collection of facilities. So I mean, like the town centre is Braintree town centre as I see it. But if you looked at that 800 metre maximum distance to a town centre, it would preclude, probably most development sites around Braintree. So I don't think you can read it in that regard. No.
Okay. So going back to where we started on this topic, the reason for refusal, which talks about a reasonable walking distance, bearing in mind that the careful analysis you've done in relation to the National Travel Survey, the various pieces of guidance, the distances involved, what's your overall judgment, please, about whether or not there is a range of services and facilities within a reasonable walking distance of the appeal site?
I think based on that analysis, there is. I mean, we've got on the in the statement of common ground in the diagram that was produced at Appendix MPG3 there, the Appendix 3, there is a range of facilities there that people could walk to reasonably from the site.
Okay, thank you. We'll come on to the qualitative aspect in a moment, the disincentive or the barriers to walking, but I just want to complete the possible mode of transport. Rail, that's an option?
Yes, rail is an option. It would involve a change of mode because you'd either have to get the bus or you could cycle to the railway station, but it is an option for people if they wanted to travel longer distance by rail to wherever they may be heading. The bus service would take you right the way to the rail station from right outside of the site. And there's also the ability to cycle. As I said, for confident cyclists, there's cycle parking at the railway station. So again, that is part of the mix of sustainable travel options that people have from the site.
Okay, thank you. And then the quality or the suitability of the walking route, in particular to Bocking, is the next point I want you to deal with, particularly by reference to Mrs. Banks's characterisation of it being an unpleasant experience. And I went through the factors with her which led her to that conclusion in cross-examination. So in the light of her answers, I'm not sure we need to spend an awful lot of time, but just by reference to your proof of evidence, you have a section on quality and safety of walking routes at page 15 and onwards.
Yeah.
And what I would just like your your comments on. First of all, the extent to which the pedestrian environment from the appeal site to the facilities in Bocking is somehow different from, unusual, more off-putting than similar locations elsewhere in the country, even the district.
That's it. As we discussed earlier on, the A131 is an arterial route heading into Braintree, so it's clearly got a reasonable level of traffic passing along it. But as do many other arterial routes heading into towns and cities across the country, I don't see it as anything unusual. And I've assessed the footway widths. I've had a look at the sort of nature and quality of the route in terms of the, I guess, the sort of ambience as you walk along. There's verges along large proportions of the A131 that offer a more sort of open aspect for the residents. They don't, as they are walking down, they wouldn't necessarily feel sort of squeezed against high barriers. And with regard to the noise issue, I don't see this as different to any other key road heading into a town. I think we've touched on the air quality issue. It's not an AQMA, so I don't see any of those aspects as preventing or being that negative as to stop people from walking from the site.
Okay. Is there street lighting on any of the pedestrian route to Bocking?
It's street lit the whole way, yes, down the A131, and there is overlooking, because you've actually got dwellings overlooking the footway. So again, it was a sort of a dark, quiet country lane. People may be concerned about that, but this does have sort of surveillance from neighbouring properties as people are walking down, which may be a positive as well for people if they were a bit nervous.
Okay, so your overall view, please, about whether the quality or suitability of the pedestrian links between the appeal site and Bocking would operate as a disincentive to people walking as opposed to getting into the private combustion engine car.
I don't see it as a disincentive. I don't see it as any different from a large number of similar routes heading into towns and cities across the country. It's footway widths, the facilities are not different from a large number of other similar situations across the country. I don't believe it represents that much of a sort of negative experience that people would be put off from walking along it.
Okay, thank you. I'm not going to ask you any additional supplementary questions about the other three schemes which were granted planning permission in High Garrett. I think we've covered the correct policy approach to that. Would you please go to the final page of your proof, where you draw everything together at paragraph 9.1.6, where you say proposals offer walking, cycling for competent cyclists, bus, rail, electric cars as realistic, sustainable travel options for residents. This choice of modes means that residents will not be reliant upon the private car. As such, the development is compliant with national policies. There are no identifiable highways or transport reasons why the development should not be approved, and you therefore respectfully ask the inspector to allow the appeal. Do you still hold those overall conclusions?
I do, yes.
Thank you very much. Mr. Grist, if you'll wait there, then I'm sure Malone Fred will have some questions for you.
Thank you.
Thank you, Mr. Easton. Mr. Williams, you may
Thank
now
you very much.
please carry on.
Thank you very much, sir. Can you hear me okay, Mr. Grist?
I can, Mr. Williams, yeah.
Thank you. For purpose notes, I can't guarantee these are all the documents we'll go to, but we may need to hand, at least electronically, the NPPF, the IHT guidelines, which is CD 8.7, the main statement common ground, CD 8.10, manual for street, CD 8.8, the transport statement, CD 110, and your proof and appendices, Mr. Grist, and Ms. Banks' proof and appendices?
Thank you. Yes, I've got all those in hard copy.
Excellent. Good. Right. Can we start, please, with the NPPF and para 105 of the NPPF? And I think happily I can cut short my questioning on this, because I think you agree, don't you, that the proposition that significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes applies to this proposal?
That's correct, yes.
And in particular, you accept, and we'll come on to see this, that this proposal, for the purposes of paragraph 105, is a significant development?
I think so, yeah. I'm not 100% sure what a significant development is, but I believe it to be relatively significant, yes.
We'll come on to that point in a moment, but certainly you identify this as a relevant paragraph of national policy in your proof of evidence.
It is, yes.
And then if we pick up the transport statement at CD 110, this was a transport statement that's dated the October 2020.
Yes.
And if we turn into PDF page 4, it was prepared by Mr. Ford, but approved, I believe, by yourself.
That's right, yes.
And if we go on in it to page 8, which is PDF page 9, at paragraph 4.1.2,
yes, I've got that, yeah.
you cite the relevant part of the now paragraph 105 that was then in the 2019 version of the NPPF.
Yes, that's there, yes.
It follows, therefore, doesn't it, that you accept the objective of focusing development on locations which are or can be made sustainable is an objective which applies to this scheme?
Yes.
Now, that objective in national policy doesn't apply to all development, does it? It doesn't apply to development which does not meet the threshold of significant, whatever that may be.
Yes, there are other policies that deal with that, yes.
I appreciate that, but this policy doesn't.
This policy doesn't, no.
And to help you and the inspector with what might be meant by significant, if we go on down paragraph 113 of the NPPF,
yes, I've got that.
we are told that all developments will generate significant amounts of movement, should be required to provide a travel plan, and should be supported by a transport statement, transport assessment. You see that?
Yes.
It would be fair to say, wouldn't it, that if a development generated a significant amount of movement such that it triggered the requirement for a travel plan or transport statement, that it probably is likely to be considered significant for the purposes of 105?
It could be, I guess it would depend on the nature of the development and its trip generation, because you could get a quite small, sort of innocuous, on the face of it, land use that could generate significant numbers of trips that might require a travel plan or a transport statement. So I don't think you can draw that exact conclusion, because different land uses generate different rates of trips.
I understand that, Mr. Grist, but if we look at 105 and what's meant by significant development, happily we accept that it's met here. But that is a paragraph 105 which is found within the chapter on promoting sustainable transport. So even if an innocuous development happens to generate quite high levels of trip movements, that would be significant in transport terms.
It would be, yes, and it would require that the county would probably require you to develop a transport statement based on that land use, yes.
And in this case, the application was supported by a transport statement, so the trigger in 113 was met.
It was, yes.
And you're proposing a travel plan, to be heard before.
That's correct. Yes, we're proposing a travel plan. Yes,
and all of that underscores the fact that as we've agreed that development of this site, 37 dwellings, is a significant development for the purposes of 105.
Yes, I think it's probably a significant development in regard to the travel plan and the trip generation. Yes.
Thank you. That's helpful clarification. Right, I want to start then with accessibility and looking at pedestrian accessibility by walking. And if we go back, please, to the transport statement at 110, the paragraph we were looking at before. As I say, this transport statement, authored by members of your team and approved by yourself.
Yeah, sorry, which paragraph were you at?
Paragraph 4.1.2.
Yes, yeah.
And you tell us what you understand by the relevant national policy, or what it requires. You say the requirement to locate residential development within walking distance of day-to-day needs is set out in the national policy, and then you cite 105. Do you see that?
Yes.
And you've done that, don't you? Because you and your team recognise that having facilities for day-to-day living within walkable distances is a key component of a location being sustainable.
It's part of it. Yes, that's right. It's an element of it. The walking distances to facilities is part of that mix.
It's part of the mix, but it's the only part of the mix that you highlight in 4.1.2, and you do so, don't you, because having facilities that provide day-to-day needs within walking distance is a key component, isn't it, of meeting that objective, which is why you highlighted it.
I wouldn't say it's it's a material part of the mix, as is public transport, cycling, all the other parts of the package. But yeah, it's a key part of it, but there are other key parts of it as well.
Okay, key part of it with other key parts. Okay, and if we then pick up your proof at paragraph 5.3.1, you went through this a bit in examination in chief. You refer to a number of standards and data about distances, and you start by referring to the Institute of Highways and Transportation guidance, which is the guidelines for providing journeys on foot, and you say it is of importance, your words.
It is of importance, yes.
And it's of importance for a number of reasons, isn't it? It's because it's published, isn't it, by the Chartered Institute of Highways and Transportation?
It is, yes.
They are the body that represents and qualifies transport experts, of which you're a member.
That's correct. Yeah, there are a number of institutes, but they're one of them, yes.
And they produce authoritative guidance for national and local governments.
They do, yes.
It's also of importance because it's the most detailed guidance, despite its age, about acceptable walking distances, isn't it?
There's quite a lot of work in that WIG document as well, but I'd agree that the table in there is probably more detailed than you see in PPG 13 or Manual for Streets. But I think the reasoning behind that table and the numbers within the other policies are based probably on the National Travel Survey, but we may come on to that.
Yeah, we'll come on to the National Travel Survey, absolutely. But your agreement with me that perhaps a different way of putting it is the IHT guidance is the most fine-grained guidance in terms of acceptable walking distances.
That's right. It does break it down in more detail, yes.
And you tell us in your proof that this guidance identifies 2 kilometres as the maximum suggested acceptable walking distance for pedestrians without mobility impairment.
That's correct, yes.
Now, if we just take up, please, CD 8.7 and table 3.2, which is at page 12 of the extract, PDF extract.
Yes, I've got that.
If we just look above, please, at 3.32 explains what table 3.2 contains. It says it contains suggested acceptable walking distances for pedestrians without a mobility impairment for some common facilities. These may be used for planning and evaluation purposes. And which is why you've made reference to it, because it is of importance in determining acceptable distances for walking distances for planning purposes.
That's right, yes, it's part of the guidance, yeah.
And if we look at table 3.2, we can note three things about it. Let's see if we can agree these. First of all, it divides the distances into three categories: desirable, acceptable, and preferred maximum.
That's right, yes.
Yeah. And there are gradations of how acceptable the walking distance may be.
That's correct, yes.
And for example, town centre, up to 200 metres is desirable, up to 400 metres is acceptable, and up to 800 metres is a preferred maximum.
That's right, yes.
And that recognises, as a general rule, it can only be a general rule, the further distance people have to walk to access facilities, the less likely they're to do so.
Yes, I think that's reasonable.
Secondly, the 2 kilometre distance that you reference in your proof at 5.3.1 as being the maximum suggested acceptable, that is the top of the limit of the preferred maximum, isn't it, for the commuting, school and sightseeing category of facilities? That's
right, yes.
It is for those type of facilities above what they identify in the table themselves as the acceptable distance of a kilometre.
Yeah, well, to define that as the median acceptable, because as we discussed, there's 3 levels of acceptable there, aren't there?
That's how you interpret it, Mr. Griss. I'm not going to, the inspector can make a judgment in relation to whether that's correct or not. But yeah, what it does do is demonstrate that the 2 kilometres is above the acceptable level as highlighted down the left-hand side of the column for commuting, school and sightseeing.
Well, I say that as the preferred maximum acceptable walking distance as I've set out in my proof, and that's my understanding of the table.
Okay.
Yeah.
Okay. The third point is this, that the reference you make is the upper limit of the preferred maximum for one category of facilities, for commuting, school and sightseeing. It's well above the preferred maximum for town centre facilities, and it's well above the preferred maximum for elsewhere.
It is, yes.
That's because the IHT recognises that people may tolerate walking longer distances for certain facilities than for others.
Yes, that's right.
And in particular, the IHT recognises that people may accept walking longer for commuting to work, for school and for sightseeing than town centre uses.
Yes, that's right. I think the
table.
Sorry. Yeah, I think the table could do with probably breaking down a whole host of other uses in there as well. But we have what we have in front of us here.
We do. And just on that point, you were talking about town centres before. What that reasonably interpreted means, doesn't it, is facilities or uses that would be ordinarily found in town centres, doesn't it? So, for instance, retail is a town centre use, isn't it? It's defined as much in the NPPF.
I think a town centre is more than just a retail use. It's a mixture of probably leisure, retail, employment. It's more than just retail. Retail forms part of that mix. I'd agree with you.
Yes. Okay. So I appreciate that's right. Maybe I worded my question inelegantly. A retail use would fall in the category of a town centre use.
Well, it wouldn't, because that classification there is to town centres, which, as I said, is a mixture of uses. It's not just to do with retail uses.
No, I appreciate that, Mr. Griss, but when we can go to the NPPF if you like, but you know the NPPF has a definition of town centre uses, don't you?
I don't know the exact definition of town centres, no.
Okay, well let's have a look at the NPPF quickly if we can then, please. We pick that up and go to the appendix. and we need to go to page 73 of the NPPF PDF version, and also happily hard copy. Apologies, no.
Are you looking for page 68, main town centre uses, Mr. Williams?
Yes, thank you very much. Yes, thank you, Mr. Easton. Yes, 68, main town centre uses. We can see that retail development, leisure, entertainment, and the like all fall within main town centre uses, Mr. Grist.
Yes, I see that. Yeah, which
and then if we go back to the IHT guidance, and it's not rocket science, this isn't, but when it says town centres, what it's talking about is facilities or uses that are ordinarily found in town centres.
Yes, yeah, the mixture of those uses we just looked at, yes.
And that would include retail.
It would include it, yes, as part of it, yes.
Okay, thank you. And if we, within the IHT guidance, if we go back up to 3.31 at page 11 of the PDF, 331 tells us that acceptable walking distances will obviously vary between individuals and circumstances, and it lists a number of factors that may have an effect on the acceptability in individual cases. Is that right?
Yes, there's a number of bullet points there, yes.
It identifies an encumbrance, for instance, shopping or a pushchair, as a relevant factor.
Yes.
And that would be a deterrent, wouldn't it, to, or reduce perhaps the acceptable walking distances in certain circumstances?
Yes.
And finally, general deterrent to walking. Again, that may reduce acceptable or affect acceptable walking distances.
It may do, that's right, yes.
Thank you. Now, what I would like to do is if you could keep out table 3.2, please, but then also take up CD 810, the main statement of common ground. Only the table at 3.2, but then the main statement of common ground. And we need to go to appendix 3 within that, please, which is the agreed walking distances.
Yes, I've got that, yes. This is the plan, yeah.
Yes, but we need to make sure that we're at the walking distances in appendix 3, not the crow-fly distances in appendix 2.
Yes.
And just to be absolutely clear, those are the correct distances against which you should consider the walking distances, not the crow-fly ones, obviously, because we don't expect the future occupants to be crows.
No, that's a fair point, yes.
Thank you. In terms of the nurseries that are in Bocking, it's fair to assume, isn't it, that the commuting school and sightseeing category of facilities would most readily apply to those facilities.
Yes.
And if we look at the Agnes Day nursery, that's 1753 metres away. That's above the desirable and acceptable distance.
It is, yes.
It is within the preferred maximum, but it's towards the upper end of that range, isn't it?
It is, yes.
And if we can open a third document at the same time, if we have your proof, please, and turn to page 14 of that. You tell us that on an average walking speed, that would take approximately 21 minutes to walk to.
That's right, yes.
Now, people walking to nurseries often have pushchairs and young children walking with them.
They do, yes.
And we know that both, don't we, are in the nicest possible way, encumbrances that may affect, indeed reduce the distance people are prepared to walk.
That's right, yes.
Now, the other nursery within Bocking is the Scallywags. Do enjoy the name, the Scallywags Day Nursery. That's at 2,272 metres away from the appeal site walking distance, and that is well above the preferred maximum.
It's above the preferred maximum, yes, but as I set out in my evidence, I don't believe this IHT guidance is the only relevant topic in terms of determining reasonable distances.
No, I'll come on to the other sources of guidance, but we know the importance you place on this, because you tell us about this guidance. Okay, let's look at primary schools. The Bocking Church Street Primary School is 1,990 metres walking distance from the centre of the site. That's above the desirable and above the acceptable distances for school categories.
Yes.
It is within the preferred maximum, but by a measure of 10 metres.
That's correct, yes.
Okay. And looking back at your page 14 of your proof of evidence, you tell us that the walking at an average speed would be, it would take you 24 minutes to walk there.
That's right, yes.
Now, that is a primary school, as I understand it, that runs from a reception year 4 to reception to year 6, so from about 4-year-olds till about 10, 11-year-olds. Is that right?
That's, yeah, I'd imagine that. Right, yeah, it's a primary school, so it would do, yes.
And at the younger end of that range, the 4, 5, 6, 7-year-olds, they're not going to walk as fast as the average walking speed, are they?
Not necessarily. I mean, the 1.4 meters per second is a fairly low bar in terms of walking speeds. It takes into account all types of pedestrians, so I wouldn't necessarily agree with that.
Okay. Let me put it this way: a 4 or 5-year-old is going to take longer than 24 minutes to cover the 2 kilometres, aren't they? Most 4-year-old, 5-year-olds.
No, I wouldn't agree with that. I wouldn't agree with that. I walk my children to school regularly, the distance of 2 kilometres. I wouldn't agree with that. No, we used to do it in a lot shorter time than that. But it's a matter of each child, I guess, and how fast they move. You know.
Okay, well, I'll leave that to the inspector's judgment. Okay, retail, please. We've agreed that retail falls within the town centre uses or facilities. And looking at the plan in the statement of common ground, just to cross something off, the High Garrett service station, that doesn't sell any items for day-to-day consumption, does it?
And past, it didn't look like it did. No, it was more of a car service station.
And the Stone the Crows, that's a gift shop, home furnishings. I've had a look at it. You may go there to buy some retail items, but that's not providing, nor are you suggesting it's providing day-to-day needs.
No, it could be useful, but it's not something that you need on a daily basis. I mean, I certainly forget to buy birthday cards on occasion. It would certainly be useful for that, but probably not for day-to-day purposes. No. No.
Okay. The closest retail facility that provides day-to-day needs, it's fair to say, is the Co-op, 62 Church Street, Bocking.
That's for day-to-day sort of convenience retail. Yes, the nearest location.
Yes, and we know from the agreed statement of common ground that the Co-op lies some 2,230 metres from the site, 2.2 kilometres away.
That's correct.
And we know from the IHT guidance that the preferred maximum is 800 metres for town centre facilities, including retail.
For town centres, yes, it includes retail as part of that town centre mix.
Yes, okay. So, and that's the most appropriate, we'll put it this way, the co-op doesn't, you wouldn't go there for commuting for school or sightseeing purposes.
No.
And so the most appropriate category within table 3.2 of the IHT is the town centre.
Yeah, I mean, I think this is where the table falls down, because it doesn't give you that finer grain for these sort of situations. It just gives you that town centre definition, which probably isn't adequate, really, because we're talking about something different here. We're not talking about a town centre, we're talking about a standalone convenience retail store.
We are, but okay, let's assume that the inspector's going to have to make a judgment on this. Let's assume that the inspector says, well, the most appropriate category for the co-op is the town centre because it's a retail facility. If he comes to that judgment, he would also recognise that the co-op lies some over 2 times, almost 2.5 times, the preferred maximum distance for such uses.
If he came to that conclusion, yes, but I'd hope the inspector would also consider the National Travel Survey data that we talked about earlier.
Mr. Grish, we'll come on to that, I promise you. But in terms of applying the IHT, if the inspector was of the view, well, the most appropriate guidance in relation to the town centre uses is the IHT guidance, as I say, the co-op is well over 2 times and almost 2.5 times the preferred maximum.
Yes, if he came to that conclusion, yes, that the town centre was the co-op, yes.
Okay, and if he came to a different conclusion that, okay, it's not a town centre, so I'm not going to apply that category, but it's definitely not commuting, school or sightseeing, so I'm going to apply the elsewhere category. It is some 800 metres above the, in fact, it's, sorry, some a kilometre above the preferred maximum if the elsewhere category was to apply.
It is, yes, if he was to consider that as elsewhere, yes.
And we've agreed, haven't we, that this is the closest retail shop for residents of the site, if they come forwards, to obtain day-to-day food needs. And if they're doing so, they would, on the way back, be carrying shopping, which is an encumbrance, isn't it?
I guess it depends what they purchased, but if they were just purchasing a loaf of bread or a pint of milk, it may not be an encumbrance. I don't think people would probably try and do their weekly shop at the co-op necessarily. Anyway, it's probably more of a smaller top-up shop if they were.
Okay, well let's take that point, and if we just pick up your proof at page 14, please, and your table there, you tell us that the distance in time taken that it would take an average walking speed to the co-op is some 27 minutes.
That's right, yeah.
Okay. So if somebody wanted to get a pint of milk or their dinner, they would be looking at almost an hour's round trip by foot.
That's right, but equally, if somebody wanted to walk there, buy a newspaper, buy a pint of milk and come back, then it's not that they would need to buy their dinner there. People may choose to use that convenience store for all sorts of purposes, not just to buy their dinner. Could be a number of reasons they'd use that shop. Absolutely,
and for whatever reason, if they wanted to do that walking there and back on foot, it would take them about an hour.
Yes, it would.
Not including shopping time.
Yes, it would. Yeah, 2 times 27 minutes. Yes.
Thank you. Then moving on to restaurants that you highlight. Restaurants are another example of a use which falls within the definition of a town centre use. We can go back to the MPPF if you'd like to see that.
Yes, no, we looked at that earlier. Yes, I saw that restaurants were in there.
Thank you. And we can see there are 2 potential restaurants. There's a Silver Bowl takeaway, but then there's also Weavers, and they are, taking this quickly, well above the preferred maximum for town centre facilities.
Yes, they are, yes.
And even if the inspector applies the elsewhere category, they're well above the preferred maximum for the elsewhere category of 1,200 metres.
They are, yes.
Yeah. Now, that's the facilities which are in Bocking. In terms of facilities which are not in walking distance on any view, there's no secondary school, is there?
In Bocking, no. Secondary school in Bocking, no.
There's no post office in walking distance?
No, I don't think there's a post office in Bocking. No.
There's no doctor or GP surgery in walking distance.
No.
And there's no hospital or A&E or anything like that in walking distance.
No, there isn't. You'd have to get the bus or use an alternative mode to reach those.
Now I want to move with, so we've looked at the IHT and how it matches up to that, but can we go back to your proof then, please? And back in 5.3.2, where you make reference to the manual for streets.
Yes, I've got that.
Okay. And you refer there to manual for streets, and you say it repeats the 2 kilometre distance, which PPG 13 had said offered the greatest potential to replace short car journeys. And let's just have a look at what manual for streets says in context. If we pick that up, it's CD 8.8.
Yes.
Within that, we need to go to page 45 within the PDF.
Yes, I've got that. Yeah.
And there's heading 4.4, the walkable neighbourhood.
Yeah.
And that's what this section is promoting, a walkable neighbourhood. And what it tells us are that walkable neighbourhoods are typically characterised by having a range of facilities within 10 minutes up to about 800 metres walking distance of residential areas, which residents may access comfortably on foot.
Yes.
I will come on to the next part, so don't worry about that. But just pausing there, facilities within 800 metres of the site, if we go back to the statement of common ground, we have the Hare and Hounds pub.
Yes.
Now, you'd hope that that isn't going to be a daily activity for future residents, would you? Doesn't provide them with their day-to-day needs.
No, I mean, no, you'd hope not.
We've already discussed the High Garrett service station and the Stone the Crows gift shop. They may provide some needs from time to time, but they're not providing the day-to-day needs for the future residents.
No, that's right, yeah.
So you'd accept, wouldn't you, that there are no facilities which provide the day-to-day needs for future residents that they can access comfortably on foot, according to manual for streets?
There aren't any within 800 metres, no. I mean, the statement of common ground sets that out, yes.
Yes, and it's within 800 metres that manual for streets says that residents may access those facilities comfortably, and therefore there are no facilities which provide day-to-day needs for the future residents of this site which they can access comfortably on foot.
Well, yeah, that's what the guidance says, comfortably on foot, yes.
And it follows, you accept, and I don't think there's anything between us on this, that High Garrett itself lacks the facilities to provide day-to-day needs. You need to look to Bocking for those facilities.
For day-to-day needs?
Yes.
Sorry, broke up there, yes. Yes, Bocking is where the primary school is, yes. Now,
apart from, if we look back at the Statement of Common Ground and the Appendix 3 that we've got open, apart from the hockey club and the beauty salon, the facilities in Bocking, which provide the day-to-day needs, are over double the 800 metre distance that manual for streets says residents could access comfortably on foot.
That's correct, yes.
Now, what you point out is that the next part, the walking offers the greatest potential to replace short car trips, particularly those under 2 kilometres. A few points on that. PPG 13, rather than PPS 13, that's no longer extant, is it?
It's not. No, the guidance that fed into it is still still useful. It's based on the National Travel Survey data, I believe.
And that guidance isn't repeated in either the NPPF or PPG?
That guidance, no, it's was in PPS 13, yes, but it's mentioned in Manual for Streets here.
Yeah, but it's not in the NPPF or PPG, just to confirm that. It hasn't been replicated in national policy.
No.
And what that says is that it walking offers the greatest potential to replace short car trips, particularly for those under 2 kilometres. And what the IHT tells us, and by splitting the distances into desirable, acceptable, preferred, maximum, is that within that category of 2 kilometres, the shorter the distance, the more desirable the alternative of walking to the car will be.
Yes, that's reasonable, yes.
And it also tells us, the IHT guidance, that the desirability or otherwise is dependent to some extent on the type of facilities that you're walking to. We've already seen that.
Yes.
And also whether there are any other encumbrances or deterrents.
That's right, yes.
And as we've agreed, the IHT provides more fine-grained guidance on that topic.
It does, yes, but probably not fine-grained enough.
We can always use more guidance, Mr. Grist. Okay.
Yes. Yeah.
On to the National Travel Survey stats, please, which you refer to at 5.3.3 of your proof. I want to take this in stages. We might take it a little bit slowly. You start with paragraph 5.3.3 by making a proposition derived from the 2019 National Travel Survey that just under 1/3 of journeys between 1 and 2 miles, 1,600 to 3,200 metres, are undertaken on foot. And that is 14 times the level of journeys undertaken by bus. And you tell us that just under 1/3 of journeys between 1 and 2 miles are on foot. Yes?
That's correct, yes.
Now, as I understand it, that relates to all types of journeys, for instance, for leisure, for shopping, for commuting purposes. The fact sheet tells us that, doesn't it?
Yes, it's for all journeys, yes.
And the fact sheet that you will have seen, because you looked at this data, that's available online, which is the covering sheet to the data you've derived, that also tells us that walking here, the journeys here, sorry, include walking for recreational purposes, for instance, rambling.
It does include, yeah, all trips over a 7-day period, yes.
Yes, and indeed, walking for recreational purposes, which falls in the other category, is the largest percentage of trips under 2 miles, isn't it?
Sorry, where's that data? I don't have that in my appendix.
You don't have it in your appendix? No, it's in the fact sheet that is to the covering. When you look at your appendix, what you've done is extract the spreadsheets, haven't you?
That's correct, yeah. I've got the spreadsheets with the actual data analysis in them, yes. I haven't referred to a data sheet, I don't think.
But I assumed you had read the data sheet in order to interrogate the figures.
No, I've gone straight to the actual data itself.
Okay, that's fair enough. If you haven't read the fact sheet which accompanies them, I can't ask you questions about it. I see Mr. Easton raises a hand. That's very fair enough. But the reason I assumed you had done is because you produced this evidence. That's why I'm asking questions about it. Thank you.
So Mr. Williams rightly anticipated why I raised my hand, but I'll put it down again because I think he realises that Mr. Grist can't answer questions about a document that he hasn't got in front of him.
No, I appreciate that, but I hope Mr. Easton and the Inspector will understand why I'd assume Mr. Grist may have read that document, but I understand that. Okay, I'll move on. What you say, if I understand it, is that, well, look, 1 to 2 miles is the equivalent of 1,600 to 3,200 metres. All facilities within Bocking are 3,200 metres, and then it's fair to say that this means that it supports your view that facilities are within an acceptable walking distance. That's the reason why you're raising this or relying on these statistics.
Yes, I've looked at the 1 to 2 miles category. As you say, those cover the facilities in Bocking, and therefore it's reasonable to use that data to assess what proportion of people are likely to walk there based on national statistics. Yes.
Okay. But you recognise, don't you, that the upper end of that range, the 3.2 kilometres, that is significantly further than the maximum distances identified for any facilities within the IHT guidance we've looked at.
It is, yes. So this covers distances that people eat much further than the 2.230, which is the co-op walking distance. Yes, it's significantly further than that.
But it's also, it's also significantly further if we go back to the CD 8.7 and the suggested acceptable walking distances. That range is significantly further than the acceptable walking distances set out in table 3.2 for any of the category facilities.
It is, yes. That's why that table looked at in isolation doesn't really consider the whole issue of reasonable walking distances, because it doesn't consider all uses, and it doesn't consider the fact that people would walk further than that. It's just a set of figures without the context which these tables, I believe, give to the situation.
Can I suggest to you why there's an obvious reason why the proposed guidelines for acceptable walking distances are significantly lower than the stats that you've raised in 5.3.3? And that's this. If you were going to walk to the co-op, which is 2.2 kilometres away, to get your dinner or your pint of milk or your newspaper, you'd need to return to the appeal site to cook your dinner or read your paper or put your milk into the cup of tea, wouldn't you?
You would, yes.
So if you're considering walking distances to the facility, to the co-op, you are only taking account half of the length of the journey, aren't you? Because the journey on foot is a round trip.
It is, yes, that these distances are one-way distances in the table, yes.
The distance, sorry, no, the distances in what table?
In the suggested acceptable walking distance to
yes.
facilities, yes.
The distances in the walking table are one-way distances. I absolutely agree with you on that.
Yeah.
That's the difference between the stats at the 5.3.3, because they are total walking lengths.
No, they're broken down into trip sections.
Well, where's that, Mr.
The National Travel Survey breaks trips down into trip sections, so each element of the trip is broken down. This isn't a there and back trip distance under the table at my MPG3. It's a single direction. Well,
I'm sorry, I've looked at this. I've read the fact sheet in front of it, and I've also read the spreadsheets. And there was no indication to that effect, as I understand, Mr. Grist. As I understood it, if we go to your the distances in your MPG3, yes, you. Let me ask you this way: if somebody's saying, "Well, I went on a walk to the local shop to pick up a pint of milk and came back," you're saying that would be treated as two separate trips, would you, for the purposes of this?
Yeah, that's the way the survey is written, and the guidance, the actual definitions around that, say break that trip down and into an outward trip and a return trip. So they're recorded as two trips.
They're recorded as two trips. Okay. So, but do you know how many of those trips are then multiplied up? So when there are people that have walked 1 to 2 miles, that would then turn around and walk immediately back another 1 to 2 miles.
Well, they're all included. It's a distance that people are willing to walk within 1 to 2 miles. So that would be recorded as two trips then. So there'd be the journey to to the shop, for example, and then the journey back from the shop be recorded as 2 separate trips. So 55% of people would be willing to walk to the place, whatever it was, 1 to 2 miles, and then 55 would be able to walk back. 55 out of the 177 trips on that table.
Sorry, I'm lost there because it's not 55%, is it? It's
55 out of the 177. Sorry.
Yeah,
yes.
and they've been.
Yeah.
Yes. Okay. 55 out of 177 are walk have a trip of between 1 and 2 miles.
That's correct. Yeah,
that's where you get the 1/3 from.
Yeah, that's right. Sorry, I said percent. Yeah. Not
but the trip. Sorry, maybe this is the confusion between us. Maybe we shouldn't look at the detailed stats. But the trip to the co-op is not just the 2 kilometres, 2.2 kilometres there. It's the 2.2 kilometres there and the 2.2 kilometres back, isn't it?
It is, but this data breaks that down into 2 trips. Is the point I'm making. The actual survey requires that to be recorded as 2 trips. I
see that point, and if that's the case, it might be. But what that distance would be, let's take a simple example. If you were living on the appeal site and you wanted to walk to the co-op, you would have to be walking and walk back. You'd be walking a distance not between 1 and 2 miles, but you'd be walking a distance of the next category between 2 and 5 miles because it's a round trip.
Yes, I mean you may not just go to the shop for the shop's sake. You may go there and do something else in Bocking at the same time. So you may do something else there. It may be a linked trip with something else. It may not be a round trip, might it?
Yeah, no, I appreciate that. It might be a linked trip. I appreciate that. But if you're wanting to leave the site, go to the local retail to pick up your dinner or a pint of milk or something, you then walk back. And what you would be doing is you wouldn't be within the 1 and 2 miles between 60 and 103.2 kilometres. You'd be well above that because it would be a round trip of around 4.4 kilometres.
If you added them up together, yes, but I guess the same applies for the IHT guidance. What we're talking about here is one-way trips. In general, that this table looks at one-way trips. The IHT guidance looks at one-way trips. So we've got
I think that's where we
similar sets of data on that regard.
I think that's where we differ, Mr. Grist, because it may break the trips up into different segments, but that if you're looking at the trip total in real terms, to go to the local retail shop to pick up your dinner, to walk back, you're not talking about a journey between 1 and 2 miles. You're talking about a journey of the next category, if we look at your MPG3, of between 2 and 5 miles.
If you did it all in one journey, yes.
Okay. And I suggest to you that's why there's a difference between the stats and the IHT guidance and the guidance and the manual for streets, and why they're shorter, because they recognise, as you say, that when they're suggesting the acceptable walking distances, there'd be a need to walk to the facilities and walk back.
Well, I don't know. I mean, you wouldn't normally walk to the town centre and just walk back immediately with something. It's part of, you may be doing that in hours later. So it's a different choice you make about a trip based on the time you spent somewhere.
So this is the co-op is not going to be a place where residents are going to pop to get their day-to-day needs and then return back to the site on a regular basis, in your view?
No, it's somewhere where people could walk to. I'm not saying everybody would walk there to do their daily shopping. They may choose to get on the bus. It's a 3-minute bus ride away and go there. It's that they do have the choice to make that walk if they wanted to. Okay,
bear with me. Let's just ask a couple more questions. If it were the case that the under 1/3 of journeys between 1 and 2 miles is referring to a round trip, okay? In order to come under that or within that distance, the facilities themselves would have to be between 800 metres and 1600 metres away, because you need to be able to walk there and walk back, and that would bring you within the 1.1 and 2 mile category. Do you follow my?
Right. Are you saying if that table in my MPG3 was for 2-way trips?
Not if it's two-way trips. If you're looking at if you look at 5.3.3, you're saying just under 1/3 of journeys are between 1 and 2 miles. Yes, okay. Well, if we are looking at a two-way journey, a journey to a facility and back to the appeal site. Yes.
Yeah.
Then in terms of meters, the facility would have to be between 800 meters away, half of 1600, and 1800 meters away. 1600 meters away, half of 3.2 kilometers.
But it's the same trip, isn't it? I mean, if it's taking the shop for example, that single directional trip, which is what the National Travel Survey assesses, is 1 to 2 miles. We don't know what proportion of those trips in there are the return journey. So maybe people have made the decision that they will make that one-way trip and the return trip. They're recorded as 2 separate trips at 1 to 2 miles, and that data is included within that 55 out of 177. So I don't think we necessarily make that jump, because the data may already be broken down within that distance there, within the 1 to 2 miles.
But you don't know, Mr. Grist, do you? You don't know within that how many of those are trips that are one part of a return journey.
No, but what I do know is that the trip is broken down. National Travel Survey breaks those trips down into segments, so they will be recorded as a single direction trip of 1 to 2 miles. That 55 out of 177 will include those trips.
But you don't know how many of those are part of a longer walking trip, or do you?
No, I don't. It could be a small number, it could be a large number.
No, okay. But okay,
data we've got in front of us.
Let me just use Co-op as an example, okay, and then we can move on from this. The walk to the Co-op is 2,230 meters.
Yes, that's right.
A round trip would be 4,460 meters.
It would.
That's approximately 2.7 miles.
It is, yes.
Now, if we look at your NPG3, that would fall into the category of two under 5 miles if the trip was treated as one as a whole.
If it was treated as a whole, yes, but back to the same point, I believe here. Excuse me.
We know, don't we, from this data that if in terms of walking trips between 2 and 5 miles, only 10 out of 242 journeys were of that distance.
That's correct, if that was the situation, but I believe they're captured as 2 elements, as we've already discussed.
You just don't know. You don't know the breakdown of that. Sorry, no, I was just saying, as we discussed just now, I believe they'd be captured under the 1 to 2 miles because they'd be breaking down into 2 segments. So the fact that people are actually travelling 2 times the distance to the shop may already be captured under the 1 to 2 mile category. But you don't know whether that's right or not. You don't know how many of those 55 were linked journeys. We've already gone over that.
No, all we know is that people are willing to walk 1 to 2 miles. Well, 31% of people are ready to walk 1 to 2 miles. Yeah.
Okay. The other
sorry, Mr. Williams, just jump in there. Just trying to gauge whether or not it's whether they're going to brief adjournments or not. So, do you know, give me an idea of how long roughly you've got in terms of your rest of your cross-examination?
Yes, I've got a reasonable amount to go, I'm afraid.
Okay. Well, we'll be going just over an hour and a half. So I'm wondering whether, if we just take maybe 20 minutes, are you at a point where that would be?
I've got one more series of questions on the national travel statistics. So with your leave and Mr. Grist's leave, I wonder whether it's worth us getting those out of the way, and then we can move on. If that's unless you really, if you.
No, that's absolutely, that's fine, Mr. Williams. Please proceed on that basis.
Thank you. Paragraph 5.3.5, Mr. Grist. Here you are saying 46, the National Travel Survey stats show that 46% of trips to and from school for 5 to 10-year-olds are undertaken by walking. And you say the average trip length is 1.8 miles.
Yes.
And from that, you deduce that the primary school in Bocking at just under 2 kilometres is a realistic choice for primary educational trips.
That's correct, yes.
Okay, let's just have a look at the MPG5, please. It's quite small font, so I had my glasses on. I think I don't know whether Mr. Easton will have to, you might be able to blow it up on the screen, but what we are looking at is the table headed Department of Transport Statistics, and it's table MTS 0613. And I think you've derived the data from the 2019 set, is that right?
That's right, yes. It's 2020, but that's probably COVID impacted, so I didn't use that. Yeah.
Understood that, and I'm not taking any point in relation to that. And you're looking at the column, the second of 3 rows, as it were, and we're looking at the penultimate column, the 2019 column, which is where you get the 46% of trips are walking.
Yes, that's right, yes.
And we can see, can't we, that 1% was bicycle, 47% was car and van, 2% was private bus, and 3% was local bus.
Yes, got that.
And we can see that the average trip length in miles was 1.8 miles.
Yes.
And it's got a notation 1 by the average trip length, and that is education trips of under 50 miles only. So it excluded any trips that were over 50 miles.
Yes.
So what the 1.8 miles is, it's an average length of trip to school, taking account not only of those who walk, but those who travel by car, van and bus.
Yes, that's the average trip length, yes.
It tells you nothing about the average trip on foot, does it?
No, but it shows that the average trip length is 1.8 miles and that 46% of people making, well, if you took the average trip, would actually walk that 1.8 miles. So it
doesn't, with respect, Mr. Grish, does it? What it shows is that the average trip, taking account of those who walk, but also those who travel by car and bus, up to 50 miles, is 1.8. And therefore it tells you nothing about the average length of trips on foot.
No, it's an average trip over all modes, yes.
Okay, and the figures will be distorted by the trips in the car and bus because they're likely to be the longer trips.
They may be, yes, they could be.
And that will have the effect of increasing the overall average trip length.
It could be, yes. I guess we don't have the sort of the detailed data to prove that one way or the other. But it could be the case.
Let's say it's a reasonable assumption. We know that the trip lengths are capped at 50 miles. The footnote 1 tells us that. Yes?
Yes, that's right, yes.
So we know that it does take into account trips up to 50 miles. Beyond a certain level of, let's say, 5 miles, those are likely to be trips in car and buses.
They may well be, yes.
And that's going to, taking those into account, average is going to bring up the average trip length of 1.8.
It may do, yes. We don't know the length of all the journeys that go to make up that average. So,
yeah.
Yes, I agree. It could do, yes.
What 1.8 miles is not the average trip length of those who walk to school.
No, it's the average of all modes, yes.
Did you know that when you were writing your proof, Mr. Grish?
Sorry?
Did you know that when you were writing your proof? You appreciated it?
I did, yes, I did. I didn't know that until now. Yes, I've made a error on that point, I believe.
Yeah, okay, so that's very fair of you, Mr. Grist. So if we look at we go back to your proof at 5.3.5.
What I've said.
You have to recognise that the reliance on the average trip length of 1.8 miles, and that indicating that the primary school is located.
I'm so sorry to interject here. I think Mr. Griss was trying to complete. He was trying to say something else.
Sorry, Mr. Easton.
Right.
Yeah, I was just trying to say that yeah, that the 1.8 miles is the average trip length I've said in my proof there. Yes.
You have, yes, 5.3.5, but from that you deduced, as we went through, that walking is a realistic choice from for primary age education trips. But the 1.8 miles average trip length tells us nothing about the average trip length on foot, does it?
No, the 1.8 miles is an average across all modes, yes, but I think we can look at other guidance to say that the 1.8 is likely to be walkable.
The deduction in your proof there at 5.3.5 is what lawyers would call a non sequitur. The stats are not averages of trips to school by foot, and therefore don't support your proposition that walking is a realistic choice for primary education trips.
That element alone doesn't, but I don't agree that, based on my analysis, that walking to primary school of 2 kilometres isn't reasonable.
So those are my questions in relation to the stats. We're moving on to a slightly different topic now, so if you want to break, we can begin a moment.
Okay, the time's, it's now 26 minutes past 3. I propose we just have a short adjournment and we'll then finish off with Mr. Grist before I adjourn the inquiry until next Tuesday. So if we can resume at 20 to 4, please.
Thanks, sir.
Thank you. Okay. The time is now 20 to 4. I'll resume this inquiry. Mr. Williams, continue, please.
Thank you very much, sir. Thank you very much, Mr. Chris. We're going to move on to the quality of the walking route now, please. And could you pick up the IHT guidance, CD 8.7, page 50 of that PDF, page 13. And we need to look at paragraph 340.
Yes, got that.
And that tells us that if people are to choose to walk rather than drive, at least for more short trips, the pedestrian environment must be more than just functionally adequate. It needs to be of high quality so that the walk is a pleasant experience. And so the IHT guidance is stressing that the quality of the walking route, influences whether people choose to walk or not.
That's right, yeah.
And they say that being functionally adequate is not enough to persuade people to walk. It should be of a high quality or pleasant experience.
That's what it says, yes.
And similarly, in Manual for Streets, CD 8.8, we pick up, please, page 63 of the guidance. Similar point being made. Page 53 and 6.3, pedestrians in paragraph 6.3.1. The propensity to walk is influenced not only by distance, but also by the quality of the walking experience. So that's the point being made by IHT, or the same point. And then it goes on to say, a 20-minute walk alongside a busy highway can seem endless. It's in a rich and stimulating street such as town centre, it can pass without noticing. And then finally, just for your reference, before we come on to consider this, if we turn to page 67, please.
Yes.
Paragraph 6.3.19. Streets with high traffic speeds can make pedestrians feel unsafe. Designers should seek to control vehicle speeds below 20 miles an hour in residential areas, so pedestrian activity is not displaced. That recognises, doesn't it, that whether or not there's an actual safety risk, high traffic speeds can cause a perception of the route to be unsafe.
High traffic speeds, yes.
That can dissuade some pedestrians from walking.
Yes, that's what it says, yes.
And albeit in the context of the Manual for Streets, obviously on streets and not particularly roads, but that they consider that it should be controlled below 20 miles an hour, which is the level at which pedestrian activity won't be displaced.
Yes, that's what it says, yes.
So what we know from the MFT guidance, from that which we've seen before and that on this page, is that walking next to a busy highway for, say, an extended period of time can dissuade people from walking, and the speed which cars are travelling can dissuade people from walking.
It can do, yes.
Now, the A131, that is, as you've accepted, one of the main arterial routes out of or around the town of Braintree.
It is an arterial route into Braintree, yes.
And there's a 40-mile-an-hour zone in the vicinity of the site.
That's right. There's a 40-mile-an-hour speed limit, yes.
And you will have observed the traffic on a number of occasions in the vicinity of that site, and it is a fast-flowing road, isn't it, where traffic does tend to travel at or near to the speed limit?
I haven't done a speed survey, but the traffic seems to be flowing relatively freely through there.
Yes, freely, but also
seems to be generally at or below 40 miles an hour, but we haven't done a speed survey, so I couldn't say definitively.
No, that's why I was asking for your judgment. The inspector will make his judgment based on his site visit as well, but it is a free-flowing road where traffic tends to travel at around about the speed limit, around about 40 miles an hour.
Yeah, it'll be at or under the speed limit, yes.
Okay. If we just pick up, please, the transport statement CD 1.10, you've got a helpful figure at page 9. And we can see the ring road around Braintree, which is for the majority of it in the south section, the A120.
Yes.
And that is, at that stage, a dual carriageway.
Yes.
And then the A120 heads off east. We can see it's the green road heading off east at the roundabout where the Tesco's is on the eastern side of Braintree.
Yes.
And it's then the A131, which is from that point a single lane heading up to the north.
Yes.
And so traffic either coming out of Braintree or going round Braintree and heading to the north of the district to, let's say, the towns of Halstead or Sudbury or beyond it, Bury St Edmunds, they would be using that A131 as the primary route.
It's the primary route out in that direction, yes.
Now, you would accept, wouldn't you, that the A131, and including the area where the appeal site is located, is a busy road?
A busy road, yeah, I don't know what the definition of a busy road is, but it's an A road, it's an arterial road heading into Braintree, yes.
Okay, well let's get some figures. It helps you. If we look at your page 19 of the transport statement, paragraph 4.9.
Yes.
That gives us traffic count from a few years ago now, from July 2017, over the course of a week.
Yes.
And gives us the flows for the AM peak and PM peak.
That's correct.
And in rough terms, I'm not being absolutely precise, but in rough terms, in the AM peak, there were approximately 1,800 combined cars heading north or south in the hour.
That's correct, yes.
So approximately 30 cars per minute.
Sorry, 30. Well, vehicles don't flow in exact in that profile, do they? They move in platoons, and there isn't an exact profile. You can't make that assumption. But
no, but that's why I said approximately.
What we know is that the peak hour. We know the peak hour flows there. We don't know that temporal distribution across the hour to break that down.
So I appreciate that. We're just getting a sense of whether this is a quiet road or a busy road. And you said, well, it's hard to judge, and I'm taking some stats, but we're talking about 30 cars per minute approximately. And some minutes will be higher and some minutes will be lower.
That's right, yes.
And that's, again, with the same caveat, 1 every 2 seconds.
If you agree, yes, that they don't travel equally across the hour, yes, they travel in platoons. Yeah.
Taking that data, and it's similar in the PM peak, I won't go through, but taking that data, taking your observations, it is fair to refer to this road, as the inspecting Thistlefield decision did, as a busy road.
Yes, it's a main road into Braintree. I don't think we dispute that.
No, it's a main road into Braintree, but it's a busy road.
Busy, yes, busy compared to many other roads, yes.
And you'll observe this. I don't know if there's any data. I haven't looked at it, but you'll observe when you've been on site. There are a reasonable number of HGVs that use that route. When you stand there, you can't help but miss the fact that lorries use that route on a regular basis.
HGVs do use the route, yes.
And therefore, pedestrians on a journey to Bocking from the appeal site will walk on a footpath which is next to a busy highway, which won't they?
Sorry, I didn't catch that last point.
Pedestrians on a journey to Bocking from the appeal site will walk on a footpath which is right next to a busy highway.
Yeah, they'll walk on the footpath next to the A131, yes, with those traffic flows we've just discussed, yes.
And it could be fairly described as being a busy highway.
Yeah, as I said, it's busy compared to other roads, but it's not, there are busier roads across the country than the A131.
Oh, it's not the M25, I accept that, Mr. Grist, I'm not saying that. But it's exactly the type of road, isn't it, which the MFT says that makes a 20-minute walk seem, or could make it seem endless.
Sorry, the M...
Manual for Streets.
Manual for Streets,
sorry.
MFT, sorry.
Yes, MFS, sorry.
Well, it depends on the nature of that road, doesn't it? It's not the situation here where pedestrians are sort of pushed right up against the sort of carriageway with no space either side of them. There are verges alongside, so I think it isn't as bad as many other routes in that respect.
Not as bad. Okay, we'll come back to the verges in a moment, but it is the type of busy highway, isn't it? That the manual for streets is saying, well, look, this can make, well, a 20-minute stroll in other circumstances might be pleasant. Here, could be seem endless.
If you're walking down a residential road with no traffic on it compared to this, it would yeah, there would be a difference, clearly, yes, but equally it doesn't make this route unacceptable.
But it's far less attractive than if it was not along a busy road, a busy highway.
Well, there's if you're on a quieter road where you had narrower footways with high walls up against you with traffic even closer to you, then I think you might find it, you know, equally as difficult. But yeah, I don't see this route as unattractive to pedestrians as Mrs. Banks.
Quite apart from the distances involved, having to walk next to a busy highway, and we'll come on to the verges, where traffic is moving at high speeds, and where there are HGVs involved, that's going to deter at least some residents from walking to Bocking, quite apart from the distances.
Some people may be deterred, yes. Some people may be deterred for all sorts of reasons that not related to the road. The fact that they don't necessarily walk, it could be any number of reasons, but some may be deterred, yes. Equally, some may be deterred walking alongside a quiet road because of lack of surveillance and street lighting and things like that. So people make different choices based on their own mindset.
I appreciate that. Well, the inspector can make a judgment, but just in relation to the verges, you have a photograph in your proof of some of the verges, page 16.
Yes, yeah.
And just the inspector will see this on site, I won't labour the point, but the verges aren't between the pavement and the busy road, are they? They're next to it.
Yeah.
Yeah.
Sorry, I missed that point. What were you saying about the verge next to the road?
This is not a situation where you have the road, a grass verge, and then the pavement. So there's a separation between the road and the pavement. No, the pavement's next to the road.
No, I'm not making that point. Now I'm making the point that there is space alongside the footway that gives a sense of space to pedestrians. They don't feel enclosed by a high brick wall or some such.
And that applies in that location, which is further on south. But if you just pick up very quickly Ms. Banks' appendices, please, Appendix 11. If you're looking in the vicinity of the site, page 11, general views of the site. If you look at the second photograph, looking towards the site facing south, that's towards the north end of the site looking south. There's no grass verge in that vicinity. In that vicinity, you've got the wall and then the footpath and then the carriageway.
Yes, but our pedestrians wouldn't be walking along this section because they'd cross further down beyond the garage. Where we've got there's a proposed pedestrian crossing point, so I don't believe our pedestrians would be walking along this section here. They'd be on the other side of the road on a footway, and then they'd cross over slightly further down.
Let's have a look at that then. The last photograph in this Appendix 11, the inspector's seen this and will see the verges where they are. Looking across the site facing northwest, the south part of the site, again, no grass verge in that part.
But again, I think this is looking up to a point where our pedestrians would be on the other side of the road looking at that photo. They'd be walking down the other side of the road and then cross over slightly further down.
You accept, don't you, that in order to for future residents to walk to Bocking, they would have to cross the A131 twice, once by the new access you're providing, and then back across the road where there's an existing crossing just north of Church Street.
That's correct, yes.
And then they would need to cross Church Street as well.
That's correct, yeah.
So they would need to cross the road 3 times to get to Bocking and twice on the busy A131.
They would have to cross twice the A131, yes.
And of course, some people would cross there and be happy to do so, but the need to cross the busy road, not once, not twice, would deter some people from walking, wouldn't it?
May deter some people, but my view is that people make these decisions every day. People walk around the streets. They're used to crossing roads. I'd be surprised if it had a major impact on people's walking habits. It may, the odd person.
Well, with respect, Mr. Grist, people do cross roads every day, absolutely, but their propensity to do so depends on their perception of the safety of the crossing of that road. Yes?
Yes, people cross roads in all sorts of situations every day, yes.
Absolutely, no, but then their propensity to do so depends on the nature of the road, including the speed of the traffic, how busy that road is.
Or it depends on the route of where they're trying to get to, yes. It's a combination of the things. I don't believe that people would be put off from making that walking trip by having to cross the road.
And that's one of the things the inspector's going to have to make a judgment on, to what extent people would be. Your proof at 5.3.23, you point out in terms of the safety issue that there's been no personal injury collision data, which indicates there've been collisions involving pedestrians in the last 5 years.
That's correct, yes.
Now, one of 2 things could be taken from that, couldn't it? Either that this is a very safe road for people to cross, or that people don't regularly cross this road.
Not necessarily, and it depends on injury accident data. Doesn't just depend upon those factors. It depends on the number of people walking, the level of traffic. It depends on and the nature of the road. It depends on all sorts of issues.
Absolutely, but if there's been no pedestrian injuries, that could tell you, well, there's a high volume of people crossing, but it's very safe to do so. Or it could tell you very few people actually cross this road. You don't, and yeah. It could depend on those two things. It doesn't tell you one or the other.
No, or equally, you could get one person across the road, on a regularly used crossing and some sort of accident because of that. But what it does show is that currently there are no accidents for pedestrians and cyclists on this section of the A131.
Right, cycling. Could we pick up the manual for streets, please? And we need to go to page 71 and paragraph 6.4.5.
Yes. Got that.
And that tells us a very common sense point that cyclists are particularly sensitive to traffic conditions. High speeds or high volumes of traffic tend to discourage cycling.
That's right, yeah. And I guess that's the point I was trying to make, that only experienced, sort of slightly more experienced cyclists would use the route for cycling. Yes,
I'll come on to that in a moment. But because of the location of the site, if you want to cycle, realistically, there's no way of avoiding the A131.
You have to cycle on the A131, yes, from the site.
Wherever you want to go to.
That's correct.
And you tell us in your proof that confident adult cyclists would be able to undertake the journeys by this mode. It's fair to say, isn't it, that you accept from that children and inexperienced or unconfident adults won't do so, or at least won't do so on any regular basis.
No, that's right. I wouldn't expect a mother with a child learning to cycle to do so along the A131, no.
And you say confident adults would be able to undertake the journeys, but the reality is, isn't it, that the prospect of cycling on this road with HGVs going by you at around about 40 miles an hour is going to deter a number of potential cyclists from using this on a regular basis.
It would deter some, yes, but there is a section of the cycling community that commute to work by bike on all sorts of routes. Wouldn't deter all people. You know, there's still a section of cyclists that would use the route, but it may deter some, yes.
The reality is, I think you said in your chief that it would be only hardened cyclists that would use this route.
It would be people that are used to cycling, yes, and cycle regularly.
And the reality for the vast majority of future residents is that cycling won't offer a realistic alternative to the private car for day-to-day journeys.
Well, it depends on the cyclists that live in the development. As I've said, I don't think inexperienced or young cyclists would use the route, but there are a large proportion of people that do cycle regularly that may well use the route. There's a growing amount of cyclists in this country, and some people will choose to cycle along the A131 from the site. Some will choose not to.
Thank you, Mr. Chris. I heard you in evidence in chief saying about 2% of people, as a generality, do.
That's right, nationally, yeah. So that's right.
In terms of the bus provision, can we just pick up your MPG 6, your Appendix 6? And this, as I understand it from our discussions on day one, is the latest proposal in terms of the access arrangements for the site, including the proposed uncontrolled pedestrian crossings.
Yes, it includes pedestrian crossings, yeah.
Now, to travel south by bus to Braintree, Bocking and Great Notley, you'd need to cross the A131 to get the bus. You
would, yes.
And that is going to be the direction of desire for the majority of people, because that's the way where you get to Braintree, Bocking, Great Notley and the like.
I'd say yes, the higher proportion of people will travel to and from Braintree by bus.
Yes. Well, rather than travelling north.
Yes.
And what you are proposing is uncontrolled pedestrian crossings.
That's right, yes, as agreed with Essex County Council, yes.
Yes, and no refuge islands proposed.
No, that's right, as we touched on earlier, Essex County Highway Authority have had a close look at the site and determined that this would be acceptable.
But what we're concerned with the perception of safety, Mr. Grist, and that impact on people crossing the road, either to walk to Bocking or to use the bus. And it's fair to say that for some residents, having to cross a busy road with the speeds that they travel at and with the regular HGVs will dissuade them from crossing the road to catch the bus southwards. At least some residents will be dissuaded.
I guess you could say that about any location. Some people will be dissuaded from crossing roads in lots of locations. That there may be a small proportion. I don't think we can say for sure.
No, of course I can't say for sure, but let's, for some potential examples on a reasonable common sense basis, if you were a parent of young children, if you had, say, a 4 and 6 year old, it would at least pose a question of whether you cross the road to get the bus and have to get them both across the road, or put them in your car to wherever you're going.
It depends on where your trip is destined, I suppose, and the purpose of it. But I don't believe people will be put off from crossing the road. I think people are perfectly capable of making a valid judgment when they come to that crossing point. There's good intervisibility in both directions. There are gaps in traffic. I don't see it as as a problem in terms of crossing the road to reach the bus stop or head towards Bocking?
Not for all, but for some. For instance, okay, let's try another example. Elderly residents, those using, who are less fleet of foot to cross that road, because you have to be fleet of foot to cross that road. They may be dissuaded from catching a bus to go south.
I guess you could say that about any development anywhere that involves a crossing point, that some people may be deterred from doing that for
with respect, Mr. Chris,
variety of reasons. Yes.
Sorry. With respect, Mr. Chris, this isn't any development anywhere crossing any road. This is a development where you have to cross a busy A road in order to get to the bus stop.
Yes, it is. Yes.
And that is going to dissuade some people, including potentially elderly residents, from crossing that road to use the bus stop to travel south.
I don't say we can definitively say that. It may do. It may not. I don't think we can definitively say that people will be deterred from using those facilities.
Final two topics, Mr. Bishop, we'd be glad to know, so you'll be glad to know as well. Can we pick up Mrs. Banks' Appendix 3, please, the Thistle Field decision? Now, this proposal concerned the site immediately to the south and adjoining the appeal site, didn't it?
Yes. Excuse me. Let me just could I just find the
Appendix.
find Mrs. Banks's appendices a minute.
Or if you can lay your hands on the Thistle Field decision elsewhere, so you make reference to it, but I don't think exhibit it.
Yeah, that's right. Right, I think I've got it. Yeah, Appendix 3. Yes, I have it.
Excellent. As I was saying, this is a site immediately to the south and adjoining the appeal site.
Yes.
For 33 houses, so a similar magnitude as the current proposal.
Yes.
And we know that the site visit, the inspector undertook the site visit in May of this year.
Just reading the decision.
It's just under the appeal decision. It says site visit made on the 4th of May.
Yeah, got that.
And the inspector concluded, didn't he, in paragraph 9, that the walking distance, well, first of all, paragraph 8, he explained the facilities in Hyde, Garrett, and the distance of Bocking, approximately 1.7 kilometres to the southwest of the appeal site, and the facilities he listed then in the 3rd sentence.
Yes.
And then in paragraph 9, in terms of walking, he concluded the walking distance from the site to the facilities in Bocking would be prohibitive, particularly in poor weather conditions.
Yes.
Now, that of course is not binding on this inspector in any way. He can come to his own judgment about whether the walking distance is prohibitive or otherwise, but it is a material consideration to take into account.
It's a consideration, yes. I deal with that in my proof with regard to the evidence that was in front of that inspector at that time.
Yes, let's take that up. So I just wanted to have a look at that, please. 8.1.3 of your proof. It wasn't something you went to in chief. You tell us that having reviewed the evidence put forward by the appellant, you noted that there was incorrect information with regards to the bus services and frequencies. Your first bullet point. Yes?
Yes, that was correct, yes.
That couldn't possibly have had any effect on the inspector's judgment that the walking distances were prohibitive.
No, it would have affected his decision regarding accessibility in the round.
And in the second bullet point, you say well, look, he had no detailed analysis with regard to the distances.
That's right. There wasn't much evidence there.
But he undertook a site visit, and you're not suggesting, are you, that the inspector didn't know the distances, at least in approximate terms, to the local facilities for day-to-day use?
No, but I don't think the inspector had the evidence around the relevant guidance and travel data to put that into context.
And you're suggesting that he'd be unfamiliar then as an experienced inspector with such guidance, at least in general terms?
Not necessarily, but there's certain levels of interrogation of evidence, and I don't think the evidence in front of that inspector was there.
And the no evidence included of the quality, safety, nature of the walking routes. You're not suggesting that the inspector wasn't capable of walking that route on his site visit and coming to a judgment on those matters?
No, but again, I don't think there was the assessment of the widths and the assessment of the, I guess, the sort of nature of that route in detail.
You're not suggesting, though, Mr. Chris, that the inspector would have ignored the nature of the route when coming to the judgment? No,
the inspector would have walked the route, but again, there's grains of analysis around that I don't think he had in front of him. And it's correct, isn't it, that the inspector came to his judgment that for the majority of the future residents, the combination of the walking distance and the nature of the route would prohibit them walking to access facilities, at least on a regular basis. That was his judgment. That was his judgment based on the evidence in front of him, yes. And that was a correct judgment to reach, wasn't it? It was his decision based on the evidence in front of him, yes. Okay, let's try another one. It was a reasonable judgment for him to reach. Reasonable with the evidence in front of him, yes, but I wouldn't personally agree with the decision, but that was what he reached based on the evidence in front of him. Last topic, if I may. Page 27 and 28 of your proof, you discuss, amongst other things, the provision for electric charging points and the installation of broadband. Yes. And you tell us in relation to the latter, the broadband, that actually it is OpenReach, who are presumably the business that supplying the broadband, to their standard policy to provide fibre to the premises to all new residential development of this size. That's right. If you approach them, yes, they will do. And at no charge to the developer. Correct. So that's their standard policy in development of this size. And then in relation to what the NPPF says about this, can we take up the NPPF, please? And we'll pick up para 114, first of all. Yes. Within chapter 10, it does say that planning policies and decisions should support the expansion of electronic communications, including full fibre broadband connections. Yes. And then at 112D above, sorry, 112E above, sorry. Applications for development should be designed to enable charging of plug-in and ultra-low emission vehicles in safe, accessible and convenient locations. Yes. So those are both policy requirements or objectives of national policy. Yes. But they are, in addition to, not instead of, the requirement in 105 to focus significant developments on locations which are sustainable, aren't they? That's right, yes. Well, the sustainable, yeah, 105 deals with sustainable transport and the choice of modes. Those other points are dealt with in other policies, yes. And it all goes to make up the mix of reducing the need to use your car.
But in short, Mr. Grist, the provision of broadband and electrical vehicle points, whilst meeting elements of government policy which is required, does not meet of itself the requirement to locate significant development in sustainable locations.
But it adds to the ability of residents to not travel and use sustainable travel modes.
A site, so to give you an example, a site in the middle of nowhere doesn't become a sustainable location just because a developer is proposing to lay broadband to it or to provide electrical vehicle points.
It's not the only element. No, I'd agree. It's part of the basket of sustainable transport measures to reduce reliance on the private car. Yes.
Yes, and reducing the reliance on the private car isn't just about one important element, of course, is reducing carbon emissions, but it's also about encouraging people to walk and cycle, because to do so promotes a healthy lifestyle.
That's part of it. Yes, that's right. It's reducing congestion, emissions, improving air quality, and public health. Public health around ingesting emissions. Yes.
But also by encouraging people to walk and cycle to local facilities, you promote public health.
It does assist with public health, yes.
Thank you. So those are all my questions. Thank you very much.
Thank you, Mr. Williams. If there are any interested parties present who object to the development and wish to put questions to Mr. Grist, can they please indicate? Okay, I'll assume there aren't any to be put to Mr. Grist. Mr. Grist, I just have one question for you. If we can turn to your MPG6, so that's the drawing, the most recent drawing in relation to the access into the proposed access into the site.
Yes, sounds good. I
think it'd be just quite useful if you just talk to me through in terms of what these crossings are going to actually physically involve, in terms of if a member of the public was approaching a crossing on the road, what would actually be there in terms of them on one side of the road, and then them are obviously arriving on the footway on the other side of the road.
Yes, sir. So if you exited the site and wanted to head south towards Bocking, you would come out and walk along that sort of short section of footway there, and then you would come to a dropped curb with tactile paving, where you would then cross the road to the other side of the road, where there would also be dropped curbs and tactile paving. And then if you wanted to head northwards, say you wanted to go to the bus stop, then you would actually be able to walk northwards along the footway, again to get to a drop curb at the northern end of that footway. There would be tactile curbing and a drop curb there for you to get across to the other side of the road.
Okay, so in total there'd be two of these types of crossing.
That's correct, yes, and then one across the bell mouth of the junction as well, if you were wanting to walk from the development across the sort of access road of the development. There's two drop curbs there as well, just across the access.
And you also obviously you've been in discussions with the Highway Authority about this, and they commented into relation to a central refuge. And am I right in saying they came to the view that one wasn't required with these crossings?
That's right.
Yeah.
Okay. Yeah, that's correct. So they visited the site and they've come to the conclusion that these facilities are acceptable. They obviously require the upgrade to the bus stops as well, but these are secured by condition.
Okay, thank you for those clarifications. Mr. Easton, do you wish to re-examine your witness?
I do, yes, I have a few points. Thank you very much. Can I just pick up that last point the inspector asked you about, Mr. Grist? And you confirmed that the county council considered the central refuges question, but decided it wasn't possible. Well, not possible, wasn't required. Would it be possible to provide central refuges if that were necessary?
If it was necessary, yes, then they could be provided, yes. But it wasn't something required by the Highway Authority, having assessed the site and its accessibility.
Okay, I'm going to work roughly backwards, just because I've got the documents in front of me that you were asked about most recently. But so far as you were taken to paragraphs 112 and 114 of the framework in relation to broadband and electric vehicle charging points, respectively. So far as electric vehicle charging points are concerned, was the condition that is now in the set of agreed conditions or broadly agreed conditions something that the council requested or something the appellant offered?
It's something the appellant's offered, yes. It was never required. It was something that's been offered.
Okay, and with particular reference to paragraph 105 of the framework, locating significant development in areas that are or can be made sustainable, to what extent, if any, is the provision of high-speed broadband to facilitate home working and the provision of electric vehicle charging points relevant to the sustainability of a location?
As I mentioned, yes, it's part of the basket of sustainable transport measures. So it forms a part of that mix.
Okay. Then just before that, you asked some questions about the Thistle Fields appeal decision. Do you still have that in front of you in paragraph 9 especially?
Yes, I'll just pull that up again. Yes, got that.
And we know from your, thank you. We know from your proof why you take the view that you do about the appeal, about that particular appeal proposal. And we can read for ourselves at paragraph 9 what particular judgment that inspector reached in relation to that site based on the evidence that was before, forgive me, him. Did the council take the same or a different view from the inspector about the sustainability of that particular location? In pre-application discussions, look at the beginning of paragraph 9.
Yes, in pre-application discussions, there was initially, it was advised it was a relatively sustainable location, and that's included in my, I think it's one of the appendices of my proof. So it seemed that they changed their mind at some point.
Okay. There's a very lengthy section of the cross-examination which looked to the question of the extent to which people might be dissuaded from crossing the road, getting the bus, walking to Bocking. Now, I just want an overview, please, from you about that issue. If some residents were dissuaded from crossing the road or walking to Bocking, does that render the scheme unsustainable overall in your judgment?
I don't believe it does. No, as I explained, I think different people make different choices. It's about having a choice of mode. So if somebody decided, for example, that they didn't want to cross the road, they may decide to use an electric car to travel instead, which is a sustainable mode. So it's about having this basket of measures, basket of sustainable transport options, so that if they don't necessarily want to use one option, they have another option available to them. And that's what this scheme offers.
Thank you. And then in relation to the experience of walking along the footways towards Bocking, you were taken on a number of occasions to Manual for Streets. Would you take Manual for Streets up again, please? And I want to look especially at page 67.
Yes, I've got that. Yeah.
And then you were taken to paragraph 6.3.19. I note for just a moment that these references didn't find their way into Mrs. Banks's proof of evidence, but no matter. Streets with high traffic speeds can make pedestrians feel unsafe. And then there was, you did have a discussion about the traffic flows, but I'm not sure you ever resolved the question of whether, in your judgment, a road with where traffic will be travelling at or below 40 miles an hour was, in your view, a high speed road. What is your view?
No, I don't think it is a high speed. There are many roads within urban environments that are 40 miles an hour. To me, a high speed road is 50 miles an hour plus in a sort of more rural context. So no, I don't see 40 miles an hour as a high speed road.
Okay. And then just in terms, can you look at the preceding paragraph? And bear in mind, this is in the context of feeling safe from crime. Can you just cast your eye down the bullet points? Pedestrian generally feels safe from crime where? There's a list of other points there. Does the route to Bocking meet any or all of those objectives?
I think it meets all of them. Yes, it was a point I was trying to make, that there's good natural surveillance. We talked about street lighting. I've certainly not seen any evidence of graffiti or antisocial behaviour. There certainly aren't any blind corners, as I touched on. There's good intervisibility on the route. There are no sort of cul-de-sacs or dead ends, so the trapped element I can't see applies, and I've already set out that there's street lighting, so I think it's fair to say that it meets all of those points.
Okay, thank you. Now, go back to another part of the manual for streets that you were asked to look at, 4.4.1, which is on page 45.
Yes, I've got that.
And I'm going to come back to the 800 metres point in a moment, but you asked some questions about what was PPG 13, and it was, but you agreed that that's been superseded by national policy and practice, which hasn't carried forward that guidance that 2 kilometres is the distance that offers the greatest potential to replace short car trips. Is there anything in the MPPF or the PPG that talks about reasonable walking, cycling or other distances when it comes to sustainable locations for development?
No, there isn't, not that I'm aware of, no.
All right. And the view that the PPG expressed, greatest potential to replace short car trips, particularly those under 2 kilometres, how consistent or otherwise is that conclusion with the empirical data about how far people do actually walk?
It's consistent, yes, and it sort of relates to the IHD guidance, 2 kilometre preferred maximum acceptable as well. All the data and the WIG report will point to that 2 kilometres.
Okay. And then going back to the walkable neighbourhood of 800 metres, comfortable 10-minute walk on foot. Just based on your experience, how realistic is it to expect a range of services and facilities within a 10-minute or 800-metre walk?
I think if you were designing a new garden town or something, these sort of things can be planned in from an early stage, but it's not realistic when you're adding development to existing communities and towns where facilities already exist. You know, it just isn't always possible to achieve that.
Okay, thank you. Some questions about the lots of questions about the IHT guidance, but is the IHT guidance, in your view, determinative of whether a particular location is or isn't within a reasonable walking distance?
No, it isn't, and that's why my evidence looks at a number of pieces of guidance and looks at data as well to try and come to a conclusion on that point. It isn't as I said, the be all and end all. It's an element of guidance, but there's other guidance and there's other data.
Okay, thank you. And then so far, can we go to the IHT guidance table 3.2, please?
Yes.
And I think you confirmed to a learned friend that when one is looking at distances, they are one-way trips, not two-way trips.
Yes, that's correct.
Yeah. So to what extent? Let's take, for example, the acceptable commuting school or sightseeing distance of 1,000 metres. To what extent would the IHT guidance have taken into account the fact that at least some people will be doing a round trip of 2 kilometres?
Yes, that's right. It would have taken that into account. Yes, it would have considered that. Yes.
And to what extent is it reasonable to assume that the IHT guidance took into account the type of people who would be undertaking those trips? I'm thinking in particular of the school trips.
That's right. It would have taken into account the fact that you're a parent with a child making that trip. And clearly you're not just going to walk there, you're going to walk back again to your house following dropping your child off at school. So that would have been taken into account, yes. Okay.
And then can we move forward, please, in the IHT guidance to paragraph 340, which is somewhere you were taken to. And this is reference to a pedestrian environment must be more than functionally adequate, it needs to be of high quality so the walk is a pleasant experience. And it goes on to say, this requires not only the specific improvements to facilities described above, but also an urban design approach to designing, constructing and managing the pedestrian environment. This will involve multidisciplinary skills and sustained partnership working. Specific measures will include, and there's a list of measures there. So far as cleaner pavements are concerned, any judgment based on your visits to the areas as to whether or not these are pavements that are covered with dog mess or inundated and litter?
No, I haven't seen that on my visits, no.
Okay. In terms of the quality of the footway services, any point about that?
No, I haven't seen anything on the with regard to the state of the footways that would prevent people from walking. And as we touched on earlier, the county council have an obligation under the Highways Act to maintain footways. And if there was an issue, people tend to actually complain, and then it gets remedied.
Okay. Graffiti, I think you touched on when we looked at the manual for streets a few moments ago. Trees and street furniture, introducing more greenery, improved quality of street furniture, providing benches and public art. So far as greenery is concerned, how green is the walk from the appeal site to Bocking?
Yeah, it's very green, as I touched on. There's a verge alongside the footway. That photo I showed shows trees as well. There's trees alongside Church Street as well once you get off the A131, so it's a fairly green route, yes.
Okay, thank you. And then, so far as I think in your evidence to chief and cross-examination, when you were explaining the variety of guidance and empirical data that you relied upon to reach your broadly 2 kilometres is a reasonable walking distance conclusion, is that conclusion affected in any way by what I may say was a very fair concession that when you were looking at one of the National Traffic Survey tables, you recall the one in relation to school trips, the average all modes trip was 1.8 miles rather than walking trips. So even if one takes into account the correction we need to make to your evidence in that regard, does that affect your overall judgment about 2 kilometres being, or thereabouts, being a reasonable walking distance?
No, it doesn't. It still brings Bocking Primary School within that 2 kilometres into the IHT guidance.
Okay, thank you. And then this is the very last topic, please. Right at the beginning of your cross-examination, you were taken to the transport statement. Can we just go back to that briefly, please? And it's paragraph 4.1.2.
Yes.
And there was a discussion, I think it was put to you, that walking distance of day-to-day needs, what was a, let me just find the wording, an important component of determining whether a site was sustainably located, and you agreed that it was a key component but was part of the overall mix. Recall those questions?
Yeah, I remember that.
Yeah.
Yes.
Now, let's indulge Mr. Williams for a brief moment, and let's assume that you said that walking is the most important component of the mix. Is the appeal site within walking distance of day-to-day needs?
It is, yes.
Mr. Grist, thank you very much indeed. Those are all the questions re-examination I have. Thank you.
Thank you.
Thank you, Mr. Easton. Well, we are reaching a suitable point to adjourn the inquiry. Just to give a very brief cap in terms of what I set out in relation to the submissions for next Tuesday, which we discussed yesterday, just as a recap. So essentially, I've given both main parties the opportunity to respond in writing to the Broad Road decision notice and the Section 106 agreements for Broad Road, Panfield Lane and Tower lands by the time we resume next Tuesday. And I've also asked the appellant to confirm its position in relation to land west of Bradfield's road site and also its 5-year housing land supply position as well. So as I stated yesterday, if those can be provided by the time we resume next Tuesday. Mr. Williams, have you any matters you wish to raise before I adjourn?
No, thank you, sir. Nothing from me.
And Mr. Easton, any further matters?
No, other than to wish everyone a restful weekend. No, sir. Thank you.
Okay, thank you. Again, with the attendance list, please, can the council please make sure it's sent through, to my case officer. So we do have a record of obviously both the appellants and the council that are in attendance, but also if there are interested parties as well, that they're also on that list. Okay, thank you. So the inquiry is now adjourned, and we will resume next Tuesday morning at 9:30. Thank you.
Thank you very much, sir. Have a good weekend.